Well, good morning.
Good morning.
We're at our appointed time, so would like to welcome everyone, and if I can get down, welcome everyone that's here. And I know that we have Senator Pittman is online today. We have, and from the Bank Commissioner's Office online will be Tim Kemp, the Deputy Commissioner, Aaron Emerson, the examiner. There'll be 3 members of the State Banking Board that will also be online. Not all of those will talk, but they will be online today for observation or potential questions. So would like to, like I said, welcome everyone to this inaugural Joint Committee on Fiduciary Financial Institutions Oversight. And would like to start out because as time runs by, it's been several months, memories fade, and thought it might be a good idea to go through and have an overview of the 2021 Senate sub for House Bill 2074 and the provisions establishing the joint committee. And start out with our reviser, David, and if you can take us back in time and tell us what we did.
Good morning, Mr. Chairman, members of the committee. Yeah, it's kind of a little time travel back to April of last year. You might remember a Senate substitute for House Bill 2074 that was the legislation that created the Technology-Enabled Fiduciary Financial Institutions Act. This is an act that created the new financial institution in Kansas, known as the Technology-Enabled Fiduciary Financial Institution, or TEFI, as I'll kind of go on from here. This institution, financial institution, would be under the supervision of the Office of the State Bank Commissioner, OSBC. The bill passed the Senate 39-0 on April 8th, the House 103-20 on April 9th, and then was approved by the governor April 21st of 2021. The bill became effective this past July 1st, 2021. So it is in operation now, subject to so the pilot program, some of the things that are happening now. Just trying to provide just a real refresher, quick overview on each of the sections, maybe with a little more detail as some of the stuff that happened in conference committee and some of the stuff on the pilot program. But section 1 of the bill is just the citation of the act, and then there's a list of definitions or some specific terminologies that are used in these TEFIs. So that's section 1. Section 2 is where that a TEFI would have to apply for a certificate of authority from the State Banking Board. And then there's also requirements before a charter can be issued. The Banking Board may require fingerprinting, a criminal history check of officers, directors, or other persons associated with the institution. Actions of the Banking Board in approving or disapproving a TEFI application would be subject to judicial review in accordance with the Kansas Judicial Review Act. Under this section, a TEFI is also required to make a distribution of cash or other assets to both the Department of Commerce and to one or more qualified charities. There is a provision that was put in the bill that the Banking Board will not approve any application until beneficent's conditional charter, which we'll talk about in section 25, has been converted to a full charter, and then the commissioner has actually completed a regulatory examination of beneficent. So it's kind of that's the first step before we start opening this up to all potential entities for a TEFI examiner. Section 3 is the fee structure. The initial fee is $500,000, and if there's an inactive TEFI, that amount would not exceed $10,000 for a fee. Of those fees, 75% is remitted to the Bank Commissioner Fee Fund, and then 25% is remitted to the newly created Technology-Enabled Fiduciary Financial Institutions Development and Expansion Fund underneath the Department of Commerce. We'll discuss that a little bit more detail in section 24. And there's also then some fees that are associated, that are assessed for the actual examination, yearly examination of the TEFIs, and then how those fees are deposited as well. Section 4 just says that the provisions of the state banking code apply to TEF fees in the same manner as they do to trust companies, with there's some modification to the terms. There are various definitions that are in the banking code that then will be transitioned to apply specifically to TEF fee, structure. Section 5 is the capitalization requirements for TEF fees. Section 6 lays out sort of the governing structure of a TEF fee. There'll be a board of directors of at least 5, but not more than 25 members. And then at least one director must be a resident of Kansas. And this section also then gives some more detail as to the structure of board meetings, vacancies, oaths, kind of just that general structure of what the board must look like under law. Section 7 is some reports that TEF fees are required to make to the commissioner, the Office of State Bank Commissioner, that their transactions are pursuant to generally accepted accounting principles. And then this also helps to calculate their capital solvency. And then this is also the section where it discusses the evaluation of a TEF fee safety and soundness as part of that examination by the commissioner and the commissioner's staff. Section 8, this is the naming and advertising requirements for TEF fees. This did come up, quite a bit in the conference committee discussion, so I kind of wanted to just touch on that. A TEF fee may not use the word bank or trust company without reference to FIDFIN, which is Fiduciary Finance Trust, or use any other term that would imply that the TEF fee is holding themselves out to the public as in the business of banking, unless the commissioner gives written approval after finding that use would not be misleading. The naming restrictions do not eliminate any trust powers granted to the TEF fee as a trust company. It's just simply how you're going to present yourself to the public. It doesn't affect the power structure. Other than indicating that TEF fee is headquartered and chartered in Kansas, the name or advertising shall not infer or imply that the TEF fee was endorsed by, an affiliate of, or connected with the government of Kansas. Section 9 is the requirement that the TEF fee maintain office space in an economic growth zone, and that was defined in the bill as a community with a population of 5,000 or less, located either in a rural opportunity zone county or Harvey County specifically. And then also required to employ, engage, or contract with at least 3 employees to provide services for the TEF fee in Kansas. And then those employees are also then help to facilitate any examinations that are required by the Act. Section 10 is provides that a TEF fee with the authority to exercise powers related to FIDFIN transactions, receiving and managing alternative asset custody accounts, and engaging in trust business. Section 11 is additional powers, duties, and responsibilities related to when they extend financing or credit to the FIDFIN trust. This is also the section where you have that required distribution in amount equal to 2.5% of the TEF fees FIDFIN transactions during the calendar year. And those distributions would be made to the Department of Commerce and to the qualified charities in that same manner that was discussed in Section 2 of the bill. Section 12 allows TEF fees to employ various professionals to assist in performing their business. They're also permitted under this section to employ agents to perform acts of FIDFIN transactions, custodial services, or trust business. And they're also allowed to license internet-related services, software, mobile apps, and platforms to or from affiliates, third parties, or other TEF fees. Section 13 allows a TEF fee to serve as custodian of an asset custody account and establishes the requirements for custodial services under the Act. Section 14 provides that any instrument providing for a trust advisor may also provide trust advisor with some, none, or all the rights, powers, privileges, authorities available to a trustee under Kansas law or under the specific instrument. Unless the instrument provides otherwise, that trust advisor will have no greater liability to any person than would a trustee holding or benefiting from the rights provided by the instrument. Section 15 exempts an excluded fiduciary from liability, either individually or as fiduciary, from any loss that results from compliance with the direction of the trust advisor or results from failure to take any action proposed by an excluded fiduciary that requires prior authorization of the trust advisor. In any action against the excluded fiduciary, the burden of proof is on the person seeking to hold that fiduciary liable, and that standard is the clear and convincing evidence standard. Section 16 provides that a trust advisor is presumed to be a fiduciary when exercising trust advisor's authority under the Act. And it's also that the trust advisor submits to the jurisdiction of Kansas for this purpose, and then instrument may appoint an individual corporation or LLC as the trust advisor. Section 17 exempts the entity appointed as trust advisor from the provisions of Article 8 of Chapter 9 of the Kansas State Statute. This is the organization article under the state banking code upon the satisfaction of the specific conditions within Section 17. Section 18 provides that the instrument may relieve and indemnify a TEFI serving as trustee for liability for breach of fiduciary duty if any such provision is unenforceable to the extent that it relieves the trust advisor or TEFI from liability for a breach of fiduciary duty committed in bad faith, intentionally, or with reckless indifference to the interest of the beneficiary. Section 19 provides the compensation of trustees, that's structured, the restrictions for compensation of trustees. Section 20 is kind of the privacy protections of those who've established that FIDFIN trust. Upon file, if they petition the court to protect that privacy, upon filing the petition, documents related to the trust and all court orders thereon shall be sealed and not made public, part of a public record of the proceeding, except that the petition shall be available to the court, the trustor, trustee, custodian, beneficiaries, and their attorneys. Section 21 provides that the commissioner may, upon written request of a TEFI prior to form submission, offer to review a form and reply with informational comments only. Such informational comments shall not constitute approval or endorsement of the form, and the TEFI shall not represent that the form has been approved by the OSBC. I know this is another thing that came up during the conference committee negotiations, and there's no approval of a form by OSBC. It's just they can review, provide some informational comments, and that's the extent of it. Section 22, this is the section that requires the commissioner adopt rules and regulations on or before January 1st of 2022 as are necessary to administer provisions of the Act. And this also allows for the OSBC to enter into contracts for technical assistance and professional services as are necessary to help adopt those rules and regulations by the deadline, and kind of provide some exemptions from some of the procurement statutes to allow for kind of a quicker thing to try to meet that January 1st, 2022 deadline. Section 23 is just that there's no maximum interest rate or charge applied between a TEFI and FIDFIN trust if the interest rate is established in the written agreement. Section 24, this is the statute that established that technology enabled fiduciary financial institution development and expansion fund and the state treasury under the administration of the Secretary of Commerce. Expenditures from the fund shall be for the purposes of distributing to economic growth zones for the purposes of economic development projects or opportunities and promoting and facilitating the development, growth, and expansion of TEFIs, FIDFIN activities, and custodial services in Kansas, and to locate TEFI office space within economic growth zones. The fund does also receive some interest earnings from Pooled Money Investment Board portfolio. Section 25, this is the what is known as the pilot program section. This section required that on July 1st, 2021, the commissioner would grant a conditional TEFI charter to beneficent and establish a pilot program. There was a $1 million initial fee and a $9 million distribution requirement specific to beneficent under the terms of the pilot program. A community in Harvey County selected by beneficent would be the first economic growth zone. Upon issuance of the conditional charter, beneficent may not actually start commencing FIDFIN transactions until the earlier of December 31st, 2021, so the end of the year, or the date the commissioner adopts rules and regulations pursuant to Section 22. The commissioner under this section is allowed to extend that date for a period not to exceed 6 months if the commissioner submits a report on or before January 10th, 2022, or the first day of the 22 session, to both the Senate Financial Institutions and Insurance Committee and the House Financial Institutions and Rural Development Committee, identifying specific reasons for why that extension is necessary. This did allow for beneficent to satisfy the applicable distribution requirement in Section 2 and the required distribution amount in Section 11 by placing those assets in an escrow account with one or more qualified charities. And then once beneficent is permitted to, convert into full FIDFIN transactions, that money would be released from the escrow. I think there was some concern about, getting those funds transferred before the end of the year for tax purposes. So that was allowed within Section 25 specifically. And then there was also, in the conference committee, there was a provision added to then also require on or before January 10th, 2022, again, that first day of the session, that OSBC would provide a report to both the House and Senate committees, updating the progress of the pilot program, and then any recommendations from the office if they need legislation to implement the provisions of the act. So then Section 26 just provides that no interest held in the FinFID trust shall be void or invalid for any common law rule. Section 27 provides that for state tax purposes, a TEFI shall be classified as a corporation, an association, a partnership, trust, or otherwise as shall be determined under the Federal Internal Revenue Code. So whatever their federal tax status is, that would be their state tax position as well. Section 28, this was the income and privilege tax credit that was introduced beginning tax year 2021 for TEFIs in an amount equal to the TEFIs qualified charitable distributions in that tax year if the TEFI maintained a principal office within an economic growth zone in Kansas. The credit could be carried forward for up to 5 taxable years. Tax credits under this would not be allowed to be sold or otherwise transferred. And then there was a provision put in during the conference committee negotiation to just say that in any taxable year, just to clarify that a TEFI would pay the greater of the qualified charitable distributions made during such year or the tax liability pursuant to the income tax or privilege tax, whatever applies there. Section 29 was the final section. This also came about during the conference committee negotiations. This is the reason why we're here today. This was the establishment of the Joint Committee on Fiduciary Financial Institutions Oversight. Melissa will be up next to kind of give you a little more detail about the charge of this committee and that, so I might let her just explain a little bit more, but I can take any questions on the remainder of the bill at the appropriate time, Mr. Chairman.
Thank you, David. Any questions for David? Senator Masterson?
Thank you, Mr. Chairman. Thank you, David. I just want to make sure in the end, under this pilot program, I want to make sure I understand kind of dates and timing and terms. And I heard conditional charter in there at one point. I didn't see permanent charter. So is commencement of transactions, custodial services and trust business, is that synonymous with permanent charter? Because they apparently can't do that till they have permanent charter. You can't do the commencement of transactions, custodial service, and trust business.
Yeah.
I was just reading around those dates. I'm in subsection C, section 25 on the pilot.
Make sure.
Under this act may not commence transaction, custodial services, or trust business in this state. Is that synonymous with permanent charter?
Yeah, that would be like, I think once the permanent charter is issued. Yeah, the conditional charter was, I think, to allow for the setup and then also those distributions to the escrow with the idea that they would go through the requirements in Section 2 and convert that to the full charter and then be good to go.
Thank you, Mr. Chairman.
Representative Finney?
Oh, thank you, Mr. Chair. I have a couple questions. I remember working on this. It seemed like we worked on this for a while in the committee. But one of the things maybe I missed it because I came in late, but this was going to be a pilot in Harvey County. And from my recollection, this is the first time in the United States that something like this has been implemented, isn't it?
Yes, I believe so, at least at the time. I don't know if that's changed now, but I know, I think this, to have it all sort of together, I think there was testimony last year, you know, there was pieces that were like in Delaware and Texas and some other states, but I think Kansas was the first state to, you know, put it all kind of
That stuck in
together.
my mind, and I was also, because I remember asking this question then, and I'm just curious as far as like, you know, if it's a big success in Kansas, it's going to attract people that want to compete. At what point can someone be able to compete with beneficent?
Yeah, that is actually section 2 of the bill. Yeah, because the board would not issue any additional charters to any potential TEFI until there's been that beneficent conditional has been converted to the full, and then there'd be some period of time for the Office of State Bank Commissioner to complete a regulatory examination. So I don't know how they would maybe schedule that, but it would be after that.
There's no indeterminate timeline that we're dealing with? Is it just kind of open?
Yes, there's no hard date in there. It'd be like on that.
Well, that answers my question. Thank you.
Mr. Chair, following on that, may I ask a question?
Yes, go ahead.
Thank you. Just on that last point that Representative Finney was going down, is it that beneficent is obviously they're carved out as part of the pilot program, they're conditional, they transition to the permanent, and then the Banking Commission has a time set, you know, they've got to basically review it from a regulatory framework. And at that point of they're finishing their regulatory review, at that point, everything opens up to any other TEFIs to be established inside of the rural opportunity zones as specified by the rest of the act. Is that right? So basically there's a step by step, but there's just no dates on when we have to have the banking commissioner have a regulatory review completed. Is that right?
Yes, Senator, that's correct. There's no, like I said, there's no actual hard date. I think part of that regulatory examination process would probably be within the rules and regs as they're established. And then I think I was to kind of provide, you know, give the office, you know, some ability to sort of figure out, you know, kind of use beneficent in that structure and then figure out what needs to happen before it goes out to other entities that provide for that full charter. So they have kind of an idea of sort of get them up to speed and have them ready to go and start approving additional charters.
For that clarification.
Any other questions? Thank you, David, very much. And Melissa, if you could kind of take us through basically our charge here today.
Good morning. One more place to mute, my apologies. Good morning, Chairman Kelly and committee members. Just a note for those who are participating online and as well for you, we have provided some resources here on our website that was displaying for you briefly. This is our committee page that includes the Joint Committee's information. It includes the agenda and minutes and the resources. And I'm not sure why it's not sharing, so I will reshare. Okay, well, our hosts are outside the room, so hopefully they'll get that posted again. And on our website, under Joint Committees, on the KLRD website, ks.gov, on the Committees Navigation tab, There is information for this joint committee, including a link to the legislature's website that includes agenda and minutes. This will be where you find the testimony for today for those of you who are appearing on our WebEx meeting or the public. That is a link to the legislature's website for the Joint Committee on Fiduciary Financial Institutions. In addition, on your resources page, there is information regarding the committee itself, its charge, and then you also have available here in paper form and electronic form online, a copy of the enrolled bill. So this is information from Senate Sub for House Bill 2074. And then you also have the Conference Committee report brief for Senate Sub for House Bill 2074. We have also provided links to the testimony on this committee resources page. You may recall House Bill 2074 originally related to insurance producer licensing. The two bills considered in the House and Senate respectively were House Bill 2398 and Senate Bill 288. And so the testimony to the two committees is available there so that you can see that information. In the memo itself, there is information for you on pages 2 and 3. This is our green memo. I have provided a timeline of those select provisions in the Act to supplement the information you have received from David. And this highlights some of those dates, including the July 1st, 2021 date, December 31st, 2021. There are a couple of provisions there regarding the issuance of the charter and the report from the Office of the State Bank Commissioner, as well as another dates of January 1st and January 10th of 2022. Those dates are provided to you as you begin your role in monitoring the oversight of fiduciary financial institutions in Kansas. There are also some annual dates that occur within the law, and those relate to assessment and fees, transmitting the statement of that from the bank commissioner to the TEFI, as well as the TEFI filing a report with the bank commissioner, and then also provisions regarding the financial institution's tax liability. So this would relate to the income and financial institutions privilege tax provisions that David referenced in the bill. In terms of the Joint Committee itself, these provisions are included in Section 29 of Senate Sub for House Bill 2074 and are codified at KSA 2021 Sup 464001. And so it's just important as we walk through this, this will be how you outline and work your way through what would be provided in the committee's report to the 2022 legislature. First, Senate Sub for House Bill 2074 established this 9-member joint committee. This will include 4 senators and 5 representatives. It's one of 2 bills that passed this year that added new joint committees. So you are one of 2 inaugural committees that have been meeting during the 2021 interim. The membership requirements that were specified in the bill provided that 4 committee members would be from the Senate, with the chairperson of the Financial Institutions and Insurance Committee or a member designated, 2 members appointed by the Senate President, and 1 member appointed by the Senate Minority Leader. The 5 members that are appearing here from the House include its chairperson of the House Committee on Financial Institutions and Rural Development, or a member designated by the chairperson, 2 members who have been appointed by the Speaker, and 2 members that are appointed by the Minority Leader of the House. Your terms are specified to begin to expire the first day of the regular session in the odd-numbered years, and specify when the chairperson would be appointed by the Speaker or by the Senate President. And your current chairperson is appointed as a member of the House. You are permitted to meet at any time and any place on call of the chairperson, and a quorum is the majority of the members. The bill also provided for compensation, travel expenses, and subsistence, and provision for professional services as may be required by the LCC. And your role is specified here in Section 29. And it is you are permitted to introduce legislation as you may deem necessary to perform your functions. You are required to monitor, review, and make recommendations regarding fiduciary financial institutions' operations in the state of Kansas, to monitor, review, and make recommendations regarding the FidFin Fiduciary Financial Institution Pilot Program, and you are also to receive a report from the Office of the State Bank Commissioner prior to December 31st that provides an update on the implementation of the TEFI Act and the pilot program. The bill required that this report include recommendations for any legislation from the OSBC that would be necessary to implement the provisions of the TEFI Act. The bill also required the OSBC to appear before the Joint Committee annually and present a report on the fiduciary financial institutions industry in Kansas. And Mr. Chairman, those are the overview of the Joint Committee's assignments. And I would note that when preparing the agenda on behalf of the committee, we did ask conferees specifically to address these items that you are responsible for monitoring, and that includes the status of the TEFI Act implementation, including specific provisions and requirements in the Act, and those would include, from the agency perspective, the status of rules and regulations for both parties, the pilot program, and the progress that's been made in meeting those requirements. And I'm happy to stand for questions, Mr. Chairman, at the appropriate time.
Any questions for Melissa? Thank you, Melissa, very much. Well, we will move from kind of the background to refresh our memories on what we're going to do here today into the presentation, and we're running right about on time. We have 135 minutes set aside for this part of our meeting today. And what I'd like to try to do in that 135 minutes is to, if we can, the presentations from Beneficient and from the Bank Commissioner, if we could look at a time period of about 50 minutes each for those. That would then leave us a period of about 35 minutes for questions and answers. And then when we go into the afternoon session, if there's any bleed over of questions or any other information, we can pick it up then. So would like to start out and welcome back to Kansas the Beneficient Company, and going to start out with introductions from a Kansan himself, Mr. Brad Hebner, the founder and CEO of Beneficient. Welcome back.
Good morning, everyone. Thank you, Chairman Kelly, for overseeing this hearing and the meeting of the committee. And I want to thank each of you for your leadership in making this new TEFI Act a reality for not only Beneficient, but for our whole industry. I'll start with introducing who we have here. I want to review and remind everyone about our board of directors. And then several members of Beneficient will provide some updates as to what we've accomplished in the last 6 months. Then I'm going to step back up at the end and give the fun part. And the fun part is what this means to Kansas and the importance of opening this up to the industry, to Beneficient's competition, and to the broader market for the alternative asset market, what that can mean here. We didn't spend a lot of time on that during the review session. And we've had enough months now to have research pulled together to where we have good hard data on where we can go with this in Kansas. Today, I have Derek Fletcher with us from our Dallas office, our President and Chief Fiduciary Officer. Many of you know him. He's got a good Southern accent from Amarillo, Texas, calming influence for all of us. I want to introduce a new member of our team, Alan Dinas. Alan Dinas is from Hays, Kansas. He is a professor of banking at Fort Hays State. He has over 40 years of banking experience in various professional executive positions in banks across the state of Kansas. Good experience with the Office of the State Banking Commissioner. And he is co-heading Beneficient Fiduciary Financial, which is our Kansas limited liability company established to run our TEFI here. And we're operating out of Heston, Kansas in Harvey County. Many of you have met Keith Martins in the past. Keith attended most every session, all the sessions with us. Keith's a resident of Heston as well. He's co-heading with Alan the Kansas TEFI, our Beneficent Fiduciary Financial. We call it BFF, so our best friend. And they're all here with us. And then Jeff King, many of you know from longtime relationships here in the legislature. He has been assisting us as an attorney at opening our doors, complying with the law, and putting together a lot of our policies and so forth necessary to operate the business. I want to take a minute and review the board of directors for BFF, for our Kansas entity. We have 8 members on our board of directors. The law does require a Kansas resident to be a director. We have currently the one Kansas resident with Alan Dynas serving on our board. And we'll be going through the process with the OSBC in the early part of the new year to receive approval and background checks on Emily Bowersock Hill. Many of you may know Emily Bowersock Hill. She's a resident of Lawrence. She is the chairman of the investment committee for Capers here at Topeka. She has a long history as an executive director at Morgan Stanley, specifically in the alternative asset space, was well known by the executives from Morgan Stanley's headquarters in New York City when we did our background review. She's had over 20 years there. She now runs her own capital company, wealth management advisory firm, that represents a lot of the types of individuals who would be clients of Kansas TEFIs. So she knows our business very well. Fantastic background degree. She has a PhD and a master's in philosophy from Yale. She has her master's from the London School of Economics, and she did her undergraduate work at Dartmouth. So one of Kansas's brightest and finest, and as soon as the background reviews are done, she'll be joining our board alongside Alan as Kansas residents. The other members of our board include 6 individuals, myself and Derek. We have Richard Fisher, who is the former CEO of the Dallas Fed and a member of the U.S. Fed's, the Washington Fed's Open Markets Committee, Open Credit Markets Committee. Alongside Richard, we have Dennis Lockhart, who was the head of the Atlanta Fed, the CEO of the Atlanta Fed. And he also served during the period of the Great Recession for Bernanke on the open markets period alongside Richard. So they have a lot of good experience in the turbulent markets that we went through a dozen years ago. We have one of the fathers of our industry, of the entire alternative asset industry. We're going to talk about, when I step back up later, the 2 markets that TEFIs can address. TEFIs are designed to be able to address the broad, large market. It's very large. Beneficent operates in a small segment of that, and we'll talk about that later. Tom Hicks is the father of the large market. So most individuals that run some of the biggest firms in our industry that are publicly traded, among the largest publicly traded alternative asset firms, at one point trained and worked for him at his firm. He was the largest in the world for about a decade in the 1980s before he took retirement from running that firm. We have, in addition, Bruce Schnitzer, and Bruce Schnitzer was the CEO and president of Marsh McLennan. Prior to that, the CFO of Marsh McLennan, one of the nation's largest insurance company and brokerage firms in New York. Bruce formed his own series of alternative asset funds to buy and sell financial institutions, principally insurance companies. And his firm is now a part of the nation's largest hedge fund called Elliott that operates out of New York City. So we have a really great board that represents a lot of strength and background in banking and in our specific industry of alternative assets. Those are 8 members of the board that I shared with you. We will be in the process during 2022, the first 3 months, of increasing our board to 11 members. So this is our inaugural board of 8. We'll be increasing it to 11 members, and you will see greater diversity coming on to the board. This board has been here in our founding stages for many years, and we're now evolving. We have a number of candidates that we are working through reviewing to add to the board of directors. As You'll hear from Derek today and from Alan. We have filled our Heston office with 6 individuals. The act requires 3 individuals. We have 6. And we expect that to grow here in the coming months as well. We have 3 open positions that we are identifying candidates and interviewing them now to fill. Yeah, I've shared with you Alan and Keith's background. We hired Jordan Bartell. Jordan grew up in Harvey County as well. His great-grandfather was the founder of Midland National Bank. Many of people in Harvey County bank through Midland National Bank. His grandfather ran it, his father ran it, and then his father sold it and merged it into a larger bank here within the last couple of years. Jordan worked at Midland National Bank, has his background in compliance in banking. He was a compliance officer for Midland National and continued in that role following the bank's sale. And now he's in charge of our compliance group in Heston. We also have Phil Regier. Phil Regier is also a great-grandson of a longtime Kansas banker. His great-grandfather founded the Heston State Bank, now the Citizen State Bank, and that bank was run by his grandfather and his father as well, and was actually owned by his mother. And when it sold, Phil Regier moved over to Midland National Bank and worked alongside with Jordan. Phil's background is in technologies. He's in charge of our technology enablement and the systems management that we are actively bringing up in the Heston office. And then we have Jeff Thiessen, who does the online credit research for the firm based in Heston. And Cammie Regier, and I will share that Cammie is Phil's wife, and she is our office manager for the space. Cammie has worked for my family for many years in the farming business and operations that we have there in Heston, and so we've moved her over to be the office manager at BFF in Heston. I'm going to ask Alan to come up and provide you an update. He's been integrally involved with the Commissioner's office, give you an update of what's been accomplished. Following that, Derek will come up and he'll talk about the economic growth zones and the structure that we're working through with the Department of Commerce in getting that implemented as well. And then I'll come back up and we'll talk about the fun stuff.
Welcome. And if you would, Alan, if you'd introduce yourself for those tuned in online for us today, and then.
Yeah, my name's Alan Dinas. I'm Director of Fiduciary Operations at BFF in Heston. I started with these folks in July of this year, so I'm a fair newcomer. Had an opportunity to come up to speed, and I'm enjoying what I'm doing at this point.
Well, welcome, and look forward to hearing your presentation.
Okay, thank you. And I want to thank you, Chairman Kelly and Vice Chairman Longbine, for the opportunity today. And to just talk about Ben and where we're at and where we're going. So we were charged with 3 questions. Melissa sent them off to us. One is the success of implementation of the TEFI requirements and our relationship with the OSBC, and how productive this interaction's been. Second one is progress on individual requirements in the bill and how or will beneficent meet those requirements. Then the status of the pilot program and how we're doing there. And then finally, we want to address maybe some proposed legislation that might happen and some of the other issues that we need to deal with. So let's start off with implementation. We've had a good relationship with the OSBC. It's interesting to work because you run into culture clashes. And course of my career, I've worked all over the world with different banks in different states, and you see this all the time. It's something you have to get used to. But what you run into with this particular business is that the language used by the state banking department and the people who run the TEFIs They use the same words, but a lot of times they mean different things. And so we've had to work through that and build some comfort and get people used to working with each other. I think going forward, close communication is critical to make sure the differences don't become a problem. The discussions we've had with the OSBC have always been candid. The OSBC has been very clear with us about what their agenda is. And while we don't always agree on a particular topic, we feel like they listen to us, what we have to say, and they do address our questions and concerns. We've had numerous meetings in person via video conferences to answer questions, to discuss any issue they or we might have. And then in mid-November, the state sent a team to Dallas, what we call a site visit, to meet our Bend team. And the commissioner was gracious enough to stay over an extra day so he could meet our board of directors as well. The board of members appreciated the Commissioner Herndon coming out, and it meant a lot to them that he's active and involved in this. Regarding the TEFI Act requirements for the issuance of a charter, we believe we've fully implemented all of the requirements for the issuance of the charter. However, the OSBC is currently evaluating two items that we need to deal with. One is audited financials. We have provided a draft of those financials along with a set of managerial finances to bridge the gap between how you would look at something internally when you operate versus the GAAP requirements. There's differences in accounting there. But the difference between the two helps explain the audited financials. The audited financials presently are in draft mode. They're being held open pending the addition of a couple footnotes that we're hoping to get clearance for very shortly. The numbers on the draft don't change. Only the footnotes change, the issuance of some capital of the final charter by the OSBC and the closing of some beneficence transactions. The second one is background checks. I don't know if this is a COVID thing or just maybe it's a 21st century. Commissioners asked for fingerprint checks on the part of the KBI background check. KBI relies upon the FBI for its fingerprint checks, and for a variety of reasons, there's a large backlog at the FBI. Presently, the FBI is silent on how long the fingerprints will take. We are in discussion with OSBC for an alternative solution. The fingerprint requirement is permissive, it's not required, and we're hoping for a quick resolution of the issue. Of note, other regulatory agencies such as the Texas Department of Banking and the Bermuda Monetary Authority have completed thorough and extensive background checks within the last 12 months of beneficence directors and senior management without any red flags or concerns of note. So that's where we are in terms of completing requirements. In terms of progress, Section 2 of the Act requires 6 conditions to issue the charter. One is the fiduciary financial institution is organized by at least one person. That's done. The name selected for TEFI is substantially dissimilar from any other bank, trust company, or TEFI doing business in Kansas. We're the only ones, so that one was easy. Articles of incorporation contain the names, addresses of the organizers. That's done. The commitment to make or cause to make a charitable distribution, we're ready to do that. And then TEFI consults with the Department of Commerce regarding economic growth zones. We've done that, and we're in contact with them periodically. We've completed all of these requirements. As far as the qualified investment part is concerned, the TEFI Act requires 10,000 square feet of commercial, industrial, multi-use, or multifamily real estate in the economic growth zone. We have certainly demonstrated our commitment in taking steps to acquire the property. To date, we have made the following acquisitions. We've had 105 Main in Heston, it's 1,000 square feet. 108 North Main, it's across the street. It's the Conference Center. It's 1,800 feet. 117 North Main, that's the proposed grocery store. That's 4,100 feet. And we're in negotiations right now to acquire 22 acres of abandoned neighborhood adjacent to the downtown area for further development. So we've made a substantial commitment towards the 10,000, and we're not done. We intend to go ahead and get that done. Section 25, the pilot program, is the other section that I'll be talking about. And I think we need to understand that the pilot program is a chance for the OSBC to become familiar with beneficence operations, or any TEFI's operations for that fact, as a full and final chartered TEFI, and to develop skills and processes necessary to regulate the industry. And for BFF to learn what it means to be regulated. Both sides have some learning to do. We hope to have a number of visitations and discourse as we work together prior to the first exam to develop examination processes and develop the reporting necessary to ensure an efficient and effective examination process. We believe the application process is complete, and we're ready. We're ready to commence operations under a full and final charter and to begin transacting business. We've learned so far that we can operate and be regulated as a banking trust company participant within Kansas under the rules and regulations of a TEFI. What we need to be careful of is trying to pound a square hole into a round peg, oops, said that backwards, and operate a number of Kansas trust banking as a member of the Kansas trust banking community. Communication is going to be essential for this to be successful. For the pilot program, our offices in Heston are operational. We have met the statutory requirements for Kansas employees. We are ready to commence operations under a full final charter prior to the December 21 holiday break. We have clearly demonstrated our commitment to complete the qualified investments in the economic growth zone economics for distribution this month. So that's my remarks. Unless there's any questions, I'll turn it over to Derek.
Do we have any questions before we go on? Thank you very much. Good morning, Derek. Welcome
Chairman
back.
Kelly. Well, thank you. I'm pleased to be back.
And could you just give a brave introduction, your name and all, for those listening online?
Yes, sir. Sure will. My name is Derek Fletcher. I'm the President and Chief Fiduciary Officer for Beneficient and BFF here in Kansas. Mr. Chairman, Mr. Vice Chairman, and members of the committee, I really appreciate the opportunity to speak before you this morning, for all the time and effort that you have invested and will invest in this process. Also, special appreciation to the KLRD team, the Revisor's Office, the OSBC, for all the work and effort that's gone into this process so far. On behalf of BFF, we are excited. We are ready for our final charter. We're ready to commence business, and we're ready to deliver economic benefits to rural communities in the state of Kansas. And so Brad thinks that he's got the fun part of today's presentation. I really do, in that I get to talk about the economic growth zones and what we believe that not only Beneficient, but the industry as a whole can do for rural Kansas. And I know a special interest to many of you here as well. And so just to briefly refresh our memories, as you will recall, when a TEFI establishes operations here in Kansas, they will create, on behalf of their clients, Kansas trusts. Assets from the customers will be placed in trust to be administered by the TEFI here in the state of Kansas. And the law requires that a certain portion of the economics attributable to the TEFI's activities are to be allocated to the economic growth zones and to the Department of Commerce. That amount representing 2.5% of the transaction size for every customer that the TEFI brings into business. So what I would like to do is just refresh our memories in terms of where those economics go, how they're administered, and what the purpose of each of the buckets are. So the 2.5% that is allocated under the statute will be divided between the TEFI Development and Expansion Fund, which is administered by the Department of Commerce, and the Economic Growth Zones. So first, with respect to the TEFI Development and Expansion Fund, the expenditures will be approved by the Department of Commerce. We've had the opportunity to meet with Commerce about the program. We walked away from that meeting really encouraged because there is a lot of enthusiasm within Commerce, a lot of excitement. They've already started the process. There's been dialogue between members of our team and the Commerce Department. How are we going to operate the program? How it will be developed? Importantly, how will it be promoted to other industry participants? And so we left really energized in terms of the excitement that exists within Commerce regarding this program. And the funds that they administer are really designed to achieve two primary purposes. The first is to provide economic benefits to economic growth zones within the state of Kansas, broadly. So as you will recall, when a TEFI comes into the state of Kansas, they will support economic growth zones that they identify in conjunction with the Department of Commerce. But what about the other rural communities that don't yet have a TEFI established to support the initiatives in their communities? That's where the Department of Commerce comes in. The Department of Commerce takes their budget and can sprinkle those funds across multitudes of rural communities to help them achieve their vision in terms of creating economic stimulus, Main Street revitalization, improved healthcare and educational facilities, whatever initiatives local community leaders believe are important to their community. Second, to use a part of those funds to promote the TEFI industry and to develop and enhance the TEFI industry here in the state of Kansas, to go out to other industry participants, inform them of the unique and comprehensive structure of the legislative construct that this body passed earlier this year, to recruit and bring in these additional TEFIs into the state so that we can further leverage and enhance the benefits that these rural communities are entitled to. And again, that is something that in particular I know the folks at Commerce have already begun this process. They've already been conducting kind of a reach out campaign to start soliciting ideas of how could we do this? What is the most effective method for reaching these industry participants? And as you may well expect with the passage of the TEFI legislation, we ourselves have had inbound inquiries from other companies with whom we conduct business and who we know inquiring about when can we start the process of being chartered ourselves. How will that work? Who should we contact? And so there's great excitement and enthusiasm building in the industry at large. So now we'll focus on the economic growth zones. And so for the economic growth zones, we need a vehicle in which to manage these funds to provide for these economic incentives in these various communities. Under the legislation, Commerce is to promulgate governing documents for a charitable foundation that would be established in each community. We are working with Commerce. We have engaged a very reputable law firm to help us develop really a prototype of what these governing documents would look like, with the intention of utilizing those for the Heston Economic Growth Zone, and then partnering with Commerce so that they could really utilize that framework to help promulgate and form additional governing instruments for future economic growth zones. There's oversight. So as we look at these foundations, the foundation would really be governed by and managed by local leaders, local members of the community. The TEFI, the chartered TEFI, would have representation on that board, but it would really be community involvement that would drive what are the initiatives that this organization should fund. And so as we all know, when it comes to financial management, there needs to be appropriate oversight. And so that oversight comes really in three separate forms. Number one, the Department of Commerce itself. This foundation would be required to submit annual reporting to the Department of Commerce in terms of here are the assets we received, here's what we use those funds for during the course of the year, here's the balance of the funds that we have available. The TEFI, having representatives on the board, would be receiving information and reporting throughout to make sure, are the funds being deployed reasonably and prudently? Are they achieving their intended purpose of stimulating economic growth and opportunity within these communities? And then finally, as a charitable organization, the foundation would be reporting to the Internal Revenue Service. So you would have Treasury Department that would be looking at it in terms of, is there compliance with the various rules and regulations applicable to charitable organizations, including proper expenditures. So this really three-legged stool in terms of economic oversight. Finally, in terms of the benefits, again, 2.5% of the FIDFIN activities generated within a calendar year would be allocated to these organizations and to the Department of Commerce. That would be funded either in cash and assets or beneficial interest, and we've had extensive dialogue with Commerce about that process. And what I'm excited to share with this committee is the fact that the demand for FIDFIN services has far exceeded really what our expectations have been. To give you a sense, we had really forecasted that upon issuance of our final charter this year, that as we rolled into 2022, that we would likely close about 260 million of FIDFIN transactions. That would equate to really 6.5 million of economic benefit to these rural communities in the Department of Commerce. What we have found is really the demand for these services is about threefold, at least currently, of what we anticipated. We have about $1.8 billion in our pipeline. Now, of that, maybe, at any point in time, 30% or so might actually make it through underwriting and be credit worthy. But we have right now in escrow 260 million of FIDFIN transactions that we could close this month when the final charter is issued that would represent 6.5 million distribution to the economic growth zones and the Department of Commerce. That is in addition to the 9 million that was required under the legislation. So by the end of this year, $15.5 million of assets could find its way to Commerce and to the economic growth zones. So very excited about that. And I will touch on the fact that Alan referenced our financial statements and the fact that they're in draft form now. The reason they're in draft form is that is intentional. What our hope is that we can add footnotes referencing the fact that we are closing these transactions. Those footnotes would be very important and very valuable to individuals and institutions that are looking to invest in Beneficient. It's a positive financial statement and financial footnote. So we're intentionally holding those, so it's not any footnotes in terms of questions regarding our accounting, but rather ones that strategically we're seeking to add if we can close these transactions this month. Finally, I would like to address a couple of ancillary items. First, as was mentioned, one of the purposes of this committee is to consider any potential amendments to the legislation. BFF, on our part, we do not believe any amendments are warranted at this time. The OSBC has identified some minor, really cleanup items that certainly could make sense, but in terms of substantive changes, we don't believe any substantive changes are warranted at this particular time. I do know that the Commissioner's Office has some more substantive proposed amendments that they, I believe, will intend to discuss, and we'd like to reserve our ability to comment on those once they've had an opportunity to make that presentation. And then finally, Representative Finney and Senator Pittman, I know there were questions in terms of the pilot program and what does that mean. And as you may recall, during the legislative process, I know there was a discussion among the various committees in terms of, do we have a particular date when business could open to other industry participants? And it was suggested that that be 2024. And through the course of discussion, it was, why do we want to impose an arbitrary date? And certainly from Beneficient standpoint, we want other participants to come here. It validates the business, right? It kind of that rising tides, raise all boats. We want the industry here. We think it's going to be beneficial for the industry as a whole. And so really the point of the discussion was when the commissioner and his team say they're ready, let's open it up. Let's don't have an arbitrary date that may be beyond the time that they are ready. And so once the commissioner's office has gain comfort that we're ready to regulate the industry at large, the industry under the pilot program could be open. Finally, there's been questions and dialogues in terms of the nature of BFF's charter. That is, as you'll recall, under the legislation, July 1st, a conditional charter was issued. What is the process to really have that charter convert, if you will, from conditional to permanent? When the legislation was first introduced, there was no conditional aspect to it. It was a charter will be issued on July 1st. BFF can operate on December 31st, subject to any extension request of the Commissioner's Office. Dialogue in the committees ensued, and there was discussion, well, should we say, just to be clear, it's a non-operative charter on July 1st, and then it will become operative on December 31st. And then that language, instead of non-operative, was changed to conditional. Our belief and our understanding of the intent was that it was conditional just to delineate the fact that we couldn't operate, we couldn't act under the charter until it was permanent, but that it would become permanent on December 31st. That has always been our intent, and quite frankly, as you can appreciate for our customers, when they come in and place their assets in trust, they want representations. They understand that these assets are going to be managed throughout their remaining useful life. And if we have to disclose, which we would as a fiduciary, that, well, we have a conditional charter, and so you can place those, but then we're going to have to go back through the application process once again, and subject to the Commissioner's discretion in terms of whether to issue a permanent charter. That is really going to be a non-starter for those customers. They are not going to want to close business because we cannot represent that we will be able to administer those assets in a fiduciary capacity for the long term. And so, again, we would very much appreciate this committee providing direction in terms of what the intent was with respect to that charter. And again, we believe that that intent was a permanent charter to be issued on December 31st, subject to any applicable extension request. With that, I will conclude my remarks, and certainly Chairman Kelly open for any questions, and can turn it over to Brad to close our portion of the presentation.
Thank you very much, Derek. And
Mr. Chairman.
And we'll turn it over to Brad for the closing.
Okay, I get to talk about the fun stuff, what this means to Kansas. And so to do that, we have to start with looking at our industry and revisit a handful of slides that were presented to the Financial Institutions Committee at the first of this year. I'm going to start with the first slide that shows you the broad market. Earlier I shared with you that there are segments to the broad market, but let's start at the broad, and then we'll come down to the segment that Beneficient operates in, and that we'll be able to grow here in Kansas, and then we can grow into the broad market. On the left side, you'll see the industry broad market growth. Today, globally across the United States, it's $9.1 trillion of institutionally managed assets. These are managed assets by registered investment advisors that are overseen and regulated by the SEC. Notice how it starts at about $900 billion in 2003. I started in the industry in 1986 when it was just beginning. It was $30 billion globally, $30 billion, and today it's $9.1 trillion. So I'm very happy I chose this industry to make a career in, but the groundbreakers in our industry, the lead groundbreaker was Tom Hicks, who's on our board of directors. He's part of the drive that drove that number from when I was $30 billion and met him in 1986, and he retired around 2010 when the industry was $3 trillion. The industry growth rate over this time period has been 14% per year. This asset class held by investors is growing at 2.3 times faster than stocks and bond asset class. These are long-term permanent alternative assets. We break the industry down on the right in a stacked bar chart. The top bar is assets held by non-U.S. institutions and individuals, $3.3 trillion. So that leaves $5.8 trillion held by investors here in the United States. We break that into three more segments here. The large institutions, that's the bottom stack. Capers falls into that stack. All the large institutions in the United States hold a value of $4.1 trillion of assets. These institutions have sophisticated resources, law firms. They have their own consultants and advisors and can spend lots of money on overseeing and managing. You can ask Emily Bowersock-Hill, who's the chairman of the investment committee at Capers. That's where they spend most of their legal bills and so forth on their investments. But individuals and small institutions don't have that deep pocket. And they represent $1.7 trillion of assets held. 900 billion of that is held by individuals now, represented by about 1.5 million households across the United States in 7 main city centers of the United States: New York, Los Angeles, the East Coast of Florida, Palm Beach to Miami. You have the Bay Area, and you have the LA and Newport Beach area, Chicago. Those are the 7 main areas where individual households own these types of assets. We target at Beneficient on that $1.7 trillion market. The reason is they do not have access to liquidity. They can't afford it. They have to hire lawyers. They have to hire advisors and consultants. And so what we have done over the many years is create a standardized process that needs to be regulated, needs to be overseen in order to deliver that liquidity. And that's the purpose behind the TEFI Act. And that's where our industry will move into Kansas in order to operate under that act and provide a simpler, a more rapid, and a much more cost-effective approach to managing their alternative asset portfolio. If we can go to the next slide. That's the broad market at $9.1 trillion. And that's not the market we're talking about first addressing under the TEFI Act. We move to the next slide. This is the yellow line on the left is our market. And this is a little bit, I'm sorry, with the right scale. The left chart, the yellow line is our market. That is the amount of transactions that seek liquidity as a segment of alternative asset banking. The blue line, of course, is the asset values. All those asset values require banking as well. Liquidity requires banking. It's a subsegment of the market. As asset values grow, the need for liquidity grows. The one dip on this line is COVID, and that's because the principal firms in the industry basically shut down during the COVID year. If you remove that COVID year out, you have a 94.94 R squared, which means it's highly correlated. As the industry continues to grow, our segment of liquidity banking grows right alongside it. It's the smaller segment. Here, it's $100 billion for the large institutions, because that's the data that's managed. We know that large institutions this year and the years after are seeking $100 billion of liquidity each year. We move to the next slide. The drivers behind this liquidity include that growth in the asset base, the growth of wealthy individual households across the United States. Growth in wealthy individuals above millionaires is the highest growth of the 5 to 25 millionaire in the United States, and they buy the most of alternative assets and have the need for the most banking. That's where that 1.7 million households come from. It's the highest growing wealth category in the United States, fastest growing. You add that to the fastest growing net asset value or market value of alternative assets, and then you add that investors are increasing their allocation to these assets. They're pulling money out of stocks and bonds, and they're putting them into alternative assets that they have to hold 15 years, as opposed to be able to sell your stock tomorrow morning. They have to hold it a long period of time. So all of these drivers lead to the non-institutional market investor, the individuals, and the very small institution. That's an additional $40 billion of demand. And the researchers and economists tell us in 5 years that's going to be $66 billion. And that adds on to the institutional number we saw on the previous slide of $100 billion. If we go to the next slide, we can see that. Here is the breakdown of the markets again. On the left, the large-scale market of $4.1 trillion. Our segment of that market is $100 billion. Above that, you have the full asset, alternative asset markets of the individuals and small households, small institutions, and that leads to another 40 billion. That's 140 billion total. And it takes about $216 billion in balance sheet assets to serve that market. So to meet that annual demand requires about 216 billion. That's our small segment of the $9.1 trillion market. But we wrote the law. We worked together to write this law to not only address our $216 billion market, but to address that $9 trillion market maybe someday. And so I want to now do the fun part and say, what's that mean to Kansas? Let's start by taking a look at the current state of banking in Kansas. This does not include trusts. This is just being able to go to your bank, borrow money. What assets do they have in your bank in Kansas? Today, Kansas State OSB supervised banks have $54 billion in total assets across Kansas. We have 186 banks that are regulated by the OSBC. We have a population here of 2.9 million. Now, that's a lot of banks. And so what we've seen happen in other states of similar populations, go in and carve in and find a banking segment that they can propose, adopt, put into law new banking rules and laws for a specific smaller segment of a marketplace. And that has driven the entire banking industry to grow, the asset base to grow, and so forth. So I'm going to pick on, we heard it before in the early part of this year, South Dakota. I'm going to pick on Utah. But Wyoming and Nevada have done the same in their banking. South Dakota implemented, beginning in 1980, special laws to focus on credit card loan banking. Utah, many years ago, 100 years ago, led the nation in industrial loan banking, which was unsecured credit for workers in industry, for blue-collar workers to be able to go in and get a loan without having to put an asset up for security. Utah led the nation in that. So let's take a look at what has happened and compare to Kansas with South Dakota and Utah. And I'm going to start by looking at the far right side of the next slide. Well, let's keep going. One more. On the far right, I'm going to compare population. We're 2.9 million population. Utah's 3.2 population, and South Dakota is 884,000 population. We're 3 times bigger. Let's go to the left side. We're going to revisit some data that I just gave you before. Kansas banks have $54.5 billion in aggregate assets. Utah, which is our same size, has over $750 billion in assets in their banks. South Dakota has $3.5 trillion in assets in their banks. They're a third of our size, and they looked like Kansas in 1980. That's what they looked like in their banking industry. Kansas has 186 banks. 68 of those, or over a third of them, represent 80% of all the assets of all banks in Kansas. Utah has 44 banks. 44 banks compared to our 186. 5 of those represent 80% of their assets in the state. South Dakota has 58 banks. 2 of them represent 80% of the assets in their state. Now, if we go back to the left side, we can find out why. Utah leads the industry at $171 billion in assets dedicated for industrial loan banking, a small fraction of their 762. South Dakota leads the industry with $222 billion in credit card loan banking, a small fraction of their overall bank assets. But the banks that do those 2 primary lines brought all their banking industry to Utah and to South Dakota. So the top part of that bar represents the core assets of banks like Morgan Stanley, Ally Bank, American Express, UBS. Anybody lease a car from BMW? Your lease is being banked through a Utah ILB. Chairman Longbine, most of Chevy's GMAC leases are going through, and they were one of the leaders, a Utah ILB for people to be able to get a car. Now, Utah started this over 100 years ago, and they armored up with the federal government as well to become the leader. 40 states followed Utah and adopted the same laws. Remember how we talked about the concern of other states stepping in and doing what we're doing? These are examples of first mover advantage. They went first, they protected their law, they got their judiciary behind the law, and they built. That 40 states has dwindled to 5 states. Utah has 93% of the U.S. industrial loan banking laws. Almost every major auto manufacturer runs their leasing programs through a Utah industrial loan bank. Morgan Stanley, our nation's largest investment banking firm, runs it through a Utah industrial loan bank. Those 40 states dropped to 5. The next leader behind them is Nevada with only 5% of the market share. Utah holds 93% of the market share. Let's turn to South Dakota. South Dakota built its $3.5 trillion asset base basically off 3 banks. It built it off of Citibank, who led it. It was kind of like a beneficiary. I wish I was Citibank, but we're the ones who came here and asked for TEFI. Citibank went to South Dakota. Followed by Wells Fargo, a California bank, pulled roots and set their bank in South Dakota, and U.S. Bank. These are the 3 main major credit card banks that then moved most all their banking assets into South Dakota. Those 3 banks alone hold 25% of all credit card loans in the industry. Now, that industry's larger, but they own 25% of it. The point that I'm making off these charts is if we focus in our small segment of, in our area, it's $216 billion of total assets. And if we focus in our small segment, we could pull a lot of the firm's other assets for alternative asset banking into the state and have a larger amount of asset base within the TEFI bank. So what's that lead to? Economic growth contributions. And we're similarly situated to these other states. South Dakota started in 1980. They started with a small percentage of the market, around 8%. And the way you can identify and know first mover advantage is working is if you have consistent annual growth in your market share of the national market share. They have consistently grown from 8% to 94%, 93.5%. Utah the same way. Utah entered with a small share with 40 other states. They led, and the other states started just dwindle behind. You're left with 6 states doing industrial loan banking, and they have 93% of the market. We're first out, so if we keep the leadership behind the law, we get busy, we get running, we have progressive regulators, progressive regulation, then we're gonna see a dynamic change in our banking asset base here in the state of Kansas. This is an interesting slide. Let's move to the next slide to just put a little bit of a punchline on the current condition for Kansas. Kansas has 0.28%, 0.25% of all assets held by all U.S. banks. But look over on the right side. We have 4.2% of all banks, of individual banks, chartered banks. We rank number 6th in the nation as the most number of banks in our state, but we're well down on the bottom of the line for the amount of assets our banks have. And so part of what a TEFI law can do is put that on its head. It can flip it. We can add a few number of banks and really grow that percentage of national assets in the banking system here. So if we look, Utah did that. Utah should have on a mean average about 1.5% of national banked assets. They have nearly 4%, and they do that with only 1% of the nation's chartered banks. South Dakota, of course, is our leading state in the nation. 1979, they were nothing. They're now our leading state with the most banked assets at 3.8 trillion or so, represents 17%, growing to 20% is the forecast for next year of all national bank assets in the state of South Dakota for a population of 900,000 people, and they have just over 1% of the banks. So these are 2 good models, and TEFI is modeled after that. Okay, now here comes the fun part, and I'm gonna move quickly here. On the left, if we move to the next slide, on the left bar, Utah targeted ILB market and captured $171 billion of that market. South Dakota targeted targeted the credit card market, secured $222 billion. And as I demonstrated before, that led to more assets coming into the state in traditional lines of banking. Our TEFI market targets $216 billion. Now, there's 16 firms that represent most all of our market, 80% of our market. The TEFI overall market, if we protect this, if we go into this small segment and perfect how we do this, the big market, then we can evolve into the $5.8 trillion market, just like South Dakota evolved into the commercial line of the market. So this is the wish list, the big $5.8 trillion number. Utah has 93.5% of their market share of ILB banking that drove their growth. South Dakota has 24.6% of their market share in the credit card banking. I would like to see us get 80% of our small segment of $216 billion, 80% of that market. So it means we need to move toward opening to the industry coming in to the state of Kansas and operating here. If we went to the big $5.8 trillion market, I would like to see us try to capture someday 20% of that market, a small market. So I kind of compare the big market to South Dakota's credit card market and the small market for TEFIs to Utah's ILB market. Now, on the left, Utah has 44 banks, 34 of which focus on industrial loan banking. South Dakota has 58. 3 banks are what drove South Dakota. 3 banks drove this whole growth for them, led by Citibank. For Kansas, we have 50 in my small segment. I'd like to see us capture 16 of those 50. If we could move to the big segment and hit the payday on the big segment, there's 2,918 firms that represent that $5.8 trillion market. Let's go find 3 of them. And Tom Hicks knows all the CEOs of all 3 of those. Let's go woo them in here with the Department of Commerce someday and bring them in here. Here's the last slide. If we can go to the last one. Utah's effort at focusing on the ILB market, building their overall banking base, has led to $745 billion of growth in their, $745 million of economic growth and impact on their GDP. Notice how the state income taxes from the banks are just $23 million to that state. Most of it comes from the multiplier effect of the assets in those banks rolling over to the communities and the way in which that money is put to work in the communities around. This is according to reports from their Department of Banking. South Dakota, on the other hand, has $7.2 billion of benefit to its state, both the GDP impact and then a small amount in taxes, $37 million. So the GDP impact, again, of the rollover effect is quite impressive, given they have a population of 890,000 people. Here's where I hope we can go. I hope that with capturing 80% of our small market and 16 firms, we can see $7 billion of overall economic impact in the state of Kansas. That is using the Brookings Institute multiplier effect for rural communities like us, like where those dollars go. But this breaks down into 2 categories. $2.8 billion is in asset transfers, cash asset transfers to the rural communities directly. 4.2 is the multiplier effect or the impact to GDP surrounding that. And then we add on here the approximate $32 million of state income taxes that are collected for banks here. So we could match South Dakota in our economic impact in just this small segment with just capturing 16 firms to run their business through Kansas trusts, managed by TEFI trust banks here in the state. If we went to the big market and caught just 3 more, the three of the 5 largest, we could see that economic impact blossom to $16 billion here in the state. $6.4 billion, that would be annual contributions to the economic growth zones. The remainder, of course, is the rollover impact from GDP. This is what gets me really excited to see the opportunity that this can represent to specifically the Ross counties, specifically the small communities in those counties, bringing things like, I've had the pleasure of being able to have a few lunches with former governors just to talk about this. About 6 weeks ago, had 2 lunches, my wife and I, with Jeb Bush, who was the longtime governor of Florida. And he said, you got to bring fiber to every single public school system. You got to bring fiber into those rural communities. That was a focus on his in Florida. So we can start to dream about how do we see this economic impact and how do we roll this out across the state. Any questions?
Okay, we're going to save questions till the end. So write your questions down that you have, and we will get up. We'll go to the bank commissioner's office next, and then we'll do questions up until our lunch break time, and then come back and finish up if we need to. So just jot them down and have them ready for the next. Thank you very much, Brad.
Thank you, Chairman.
Mr. Chair, when you said you're going to get up and go to the bank commissioner, I think that was figurative. You're not actually going to the bank commissioner's office, right?
That's correct.
Okay.
We'd like to go, we'd go out and get a stroll, but no, we will stay here. So we go into our next section, the Office of the State Bank Commissioner, and Commissioner David Herndon will be our presentation, and we have, there's several with him that will be able to answer questions too along the way when we get to the end. But Commissioner Herndon, welcome, and look forward to hearing your presentation.
Thank you. Members of the Joint Committee, my name is David Herndon, and I am the Kansas State Bank Commissioner, and appear before you today to update you on the operations of our very first technology-enabled fiduciary financial institution, known as a TEFI, in the state of Kansas from the perspective of my office, the Office of the State Bank Commissioner, oftentimes, most of the time, referred to as the OSBC. As you heard, I'm joined in person today by OSBC General Counsel Melissa Wagman and OSBC Staff Attorney Matt Shoger. Each of them is available for questions by the committee when the time comes. Joining us virtually from the OSBC until just a few minutes ago when he lost his connection, but maybe he's back on now, is Deputy Commissioner Tim Kemp and TEFI Chief Examiner Aaron Emerson. We're joined by 3 members of the State Banking Board, Chairman Leonard Wolf, board members Lee Tatum Haskell and Justin Nichols. These 3 board members comprise the ad hoc committee charged with overseeing the TEFI application and chartering process by Beneficient Company Group LP, the entity granted the pilot program in the 2021 legislation. Today, I intend to report on the status of the implementation of the TEFI Act requirements, the timeline of implementation, the status of OSBC's enactment of rules and regulations, proposed legislative changes, the status of the pilot program's anticipated start date, and the time frame for the first examination by OSBC before issuance of the formal charter. When this legislation was introduced last session, I appeared as a neutral commentator on the legislation. That neutrality continues today. However, during my testimony last session, I expressed some concerns with particular regulatory requirements and components contained in the law. Some of my concerns were interpreted perhaps as being testimony opposing the legislation. But as I just said, we are neither proponents nor opponents of this law. And I'm pleased to report that by working closely with Beneficient, several of our concerns that were expressed have been allayed. The law establishes OSB as the sole regulatory body for TEFIs chartered in Kansas. There is no federal counterpart in the regulatory field for TEFIs. And keep in mind that OSBC is a financial regulator. We regulate banks, trust companies, mortgage companies, consumer credit companies, and other financial entities licensed in Kansas. And as required by Kansas law, we will be prepared for the regulation of TEFIs. In addition to working with Beneficient on their application, we have sought guidance and fielded questions from legal, accounting, academic, regulatory, and industry professionals about the law. Anecdotally, someone suggested in one of those meetings that writing the rules and regulations for TEFIs was like building the plane while in flight. And I agreed with that analogy, but also added that sometimes I felt like I was also learning to be a pilot. Fortunately, we have a good ground crew and a willing co-pilot with Beneficient as our applicant. In terms of implementing the TEFI Act requirement, the OSBC has complied and met all deadlines imposed by Senate Sub for HB 2074. A conditional charter was granted on June 30, meeting the deadline of July 1 set in the bill. And since that time, several, but not all of the application requirements contained in the Act and also noted on the conditional charter have been satisfied. Numerous phone calls, text, emails, in-person meetings have taken place, all of which have been productive. Staff members from OSBC, as you heard earlier, traveled to Beneficient's Dallas headquarters in mid-November. A letter over my signature, dated November 18th, summarized and memorialized the discussions during those meetings and the agreements that we reached through our joint efforts to obtain, analyze, and process the information for Beneficient to establish a TEFI. Certain members of this committee were copied on that November 18th letter, but I'd like to summarize it here to establish the current state of the application. A very significant issue was the affiliation between Beneficient and GWG Holdings, a publicly traded company that we determined from our due diligence was facing potentially severe adverse actions by the Securities and Exchange Commissions and/or NASDAQ. We first became aware of these issues last spring and were assured that the issue would resolve itself through severance of the relationship between Beneficient and GWG. That action, severing the relationship, was completed on November 15th pursuant to actions by each company's board of directors and GWG's subsequent filing of a Form 8K establishing a November 29th effective date. Severing the relationship between Beneficient and GWG overcame a major impediment to the application process. Next, a key component creating delay in the applicant's lack of complete and final financial statements. You heard earlier the reasons why, but no financial analysis or due diligence could be conducted until those statements were received. We did receive the managerial statements on December 1st. These are not audited financial statements, nor do they contain footnotes or supporting schedules, so it'll take some time to analyze them appropriately and accurately, and third-party accounting assistance may be required. These are sophisticated. This would be due to the sophistication and the potential of intercompany transactions that we just right now don't have the knowledge of. We have successfully resolved, exclusively for this applicant, the issue of the law allowing intangible assets as capital adequacy. This applicant's funding sources for FIDFIN transactions, the type of trust powers for this applicant that they will need to conduct FIDFIN transactions, and the type of consideration used for these transactions. However, we and the applicant remained stymied by Section 2F of HB 2074 about the background checks for all of the applicant's officers and directors. We contact with the KBI, who in turn contacts with the FBI, and to date, only 5 of the background checks have been received. I've requested assistance from Senator Brand's office to expedite this process, but no positive results have been realized to date. We're exploring the appropriate alternatives that may be available to complete this step without relying on the FBI background completion. Consequently, although our goal remains to provide the applicant authority to conduct business in an expeditious manner, it may be necessary for the OSBC to extend the time in which the applicant can begin the pilot program and commence transactions pursuant to Section 25D of the Act. In the meantime, regulations for TEFIs have been drafted and submitted to review by OSB's third-party legal counsel. That review is relatively complete with comments and suggestions by outside counsel being reviewed by our internal counsel, and we expect that process to be complete by the end of this week or the middle of next week. Through discussions with beneficiaries, we've also gained clarity regarding some of the economic development provisions contained in the Act and how the applicant plans to comply with those. And you've heard those comments already today. We included the Departments of Commerce and Revenue in our discussions as well. OSB examination staff anticipates conducting the first examination prior to issuance of the formal charter within 12 weeks of TEFI conducting FIDFIN transactions. We believe that within this 12-week timeframe, beneficent will have booked sufficient transactions for OSBC to conduct a meaningful examination. And you heard a few moments ago that the $260 million of FIDFIN transactions ready to go and $1.8 billion in the pipeline. So we believe that that 12 weeks is sufficient time to get a book of business on which we can conduct examinations. By the way, we also do pre-opening examinations, although we've not had a new bank charter for several years. We do conduct pre-opening examinations for new banks, and we conduct examinations for new trust companies upon opening. Any examination that we would conduct, whether it's before or after the issuance of a formal charter, will address only compliance with this state law as presented in HB 2074. We'll also, however, be able to conduct information technology examinations, testing the standards for IT, cybersecurity issues, and the like. We'll be able to conduct federal examinations for federal requirements such as Anti-Money Laundering and Bank Secrecy Act rules and regulations. The examination standards given in HB 2074 preclude us from doing any safety and soundness determination that would meet our internally accepted and internationally accepted regulatory examination protocols for safety and soundness exams for banks or depository institutions. Those standards and protocols require regulatory examination to establish ratings of 1 to 5, with 1 being the highest rating, and we examine on what's known as the CAMELS acronym, which is capital adequacy, asset quality, management capability, earnings, liquidity, and interest rate sensitivity. So allow me to provide an example of how we would normally apply the CAMELS rating system. Even though the applicant and OSBC have resolved our concerns about capital adequacy for this particular applicant, the new law allows intangible assets to be included in the capital. A TEFI exchanges an alternative illiquid asset for a liquid asset by taking ownership and holding this illiquid asset in the form of a loan that is repaid with the illiquid's asset maturation. No repayment schedule established and no recourse exists to any party in the transaction. Therefore, asset quality would absolutely fail a standard examination. Also, the Act specifically disallows earnings to be considered in an examination, so we couldn't do the earnings component. And liquidity and interest rate sensitivity are not considered because they don't hold deposits, and thereby reducing liquidity need to only meeting the current operating expenses. Presumably no interest rate risk is present because by agreement with this applicant, we've resolved the funding sources that would fund FinFID transactions. Similarly, when we examine trust companies, we look at management, we look at operations, internal controls and audits, earnings, compliance, and asset management. For the same reasons given above regarding banks, a trust examination cannot be conducted to accurately reflect an industry accepted standard. Therefore, our examination activities will likely be limited to a pass-fail type of examination based on compliance with HB 2074 and the applicable federal requirements for financial institutions. Section 29F3 of the TEFI Act charges OSBC with the duty to provide recommendations to this committee for, quote, any legislation necessary to implement the provisions of, end quote, the TEFI Act. The agenda of this committee meeting directed us to provide recommended legislation for the 2022 session. Therefore, I have attached to my written testimony a bill draft which includes our recommended changes. These changes clarify some issues unique to TEFIs, in specifically what the OSB will evaluate during an exam, when the pilot program will end, what happens if a TEFI fails or stops operating either voluntarily or involuntarily, that certain required notifications to the OSB be prompt and in writing, that a FIDFIN transaction is determined to be a sale from the perspective of the customer, and when the first yearly assessment will be due. Now keep in mind, we're writing regulations, rules and regulations, not only for this applicant, but for the industry that you've heard could rapidly come into Kansas. So we've had that in our perspective as well. One recommended change adds authority to the OSB to set concentration limits for FIDFIN transactions. Concentration limits might be based on asset class, they might be based on geographic issues, industry sectors, based on unique risk portfolio for each category of transactions. Our recommended changes also harmonize some provisions with existing approaches for banks and trust companies, specifically when that the initial fees are received at the time of the application, how the fees and assessments are paid, the grounds for which an application might be denied, that the OSBC can examine TEFI's service providers, third-party service providers, that the OSBC can require insurance and extra capital, that the OSBC can require disclosures to consumers, that assessments are allocated and paid annually in July, and to the extent that TEFI can engage in traditional trust businesses, and that the TEFIs are mandatory reporters for purposes of elder abuse. Our recommended changes also make a handful of technical corrections and some minor wording improvements to better fit the TEFI context. Beneficient has agreed to several of these technical corrections, not all, but several. And again, I say we are not only preparing for Beneficient to do business in Kansas, but also subsequent TEFIs. Again, thank you for the opportunity to address this committee, Mr. Chairman. I hope my comments have reflected all the work of Beneficient and OSBC to reach the common goal of receiving, reviewing, and analyzing the information that will lead to Beneficient receiving its authority to conduct business in Kansas, successfully operate the pilot program, and our state subsequently attracting TEFIs. We look forward to a long and respectful relationship with Beneficient and appreciate the opportunity this morning to update the committee on the current status of our first TEFI in the state of Kansas. My staff and I will stand for questions when you deem appropriate from you or members of the committee. Thank you.
Mr. Commissioner, we will now, we picked up a lot of time right there, so we'll be able to go to questions and ask the preference of the committee. Would you rather break it down to specific questions for the commissioner and specific for Beneficient, or just back and forth? Does it matter? Okay. Why don't we go ahead and we'll start out first with Beneficient, and then we'll come to the commissioner, and then if there's ones that cross over, we'll do we'll do them both and allow both to respond. So I have down Representative Hoheisel, you had a question?
Thank you, Mr. Chair. Yeah, this is for Brad. Most likely for Brad. It's good to see you again. I didn't get to see you before I came in. On the federal level, there is currently a reconciliation bill with a number of tax changes in there. One of them is a new tax on high wealth individuals with unrealized gains. What would this do to your product if this became law?
Well, first, our counsel advises us that that's going to likely not, it's a proposal and likely not make it through because.
Your lips to God's ears there.
Yeah. So for us, with people locked in with locked-in gains, most of these assets do have locked-in gains. They can't just sell the assets right away. It's kind of like when you own a farm, and you had the big capital gain tax upon the death of your parents, you had to sell some acreage. These are not for sale. So actually for TEF fees, this is where the pipeline will grow because people will need liquidity out of the asset to pay the tax if that is adopted.
Thank you. Thank you, Mr. Chair.
Thank you. And Representative Owens, you had a question?
Thank you, Mr. Chairman. A couple of quick questions, if I may. Brad, based on what I'm hearing, it sounds like the only two hangups would be formalized audited financials, which again, you've submitted everything other than a couple of footnotes, and then fingerprints from the FBI. But if I'm reading this correct, neither of those are required per this statute. Am I understanding that correctly?
Derek, is that correct? That's correct.
Yeah, because I believe I saw may as it relates to the fingerprint, so that's not an absolute requirement. They may require that. And then the audited financial statements, I didn't see anything specifically in here. So you, just to clarify, you believe that you have fulfilled all the mandatory requirements for your permanent charter. Is that correct?
We do, and I'll add to it that the financial statements have gone through all the routines of a traditional audit. Our auditor is Grant Thornton, the 5th largest. They've completed all the routines. We are holding them, and those statements with complete footnotes, other than 2 that we want to have added to them, have been delivered to the OSBC by email. And we have a system between us that we work on called Smartsheet, where documents are dropped into it, and anybody can access Smartsheet from either OSBC or Beneficient as part of the working relationship. So those have been put into Smartsheet several weeks ago. The footnotes are complete. The reason, again, why we're holding it open is that we would like to close the first round of transactions. To close those transactions, you have to be able to serve as a trustee. No state in the United States, and the OCC does not permit a company to serve as a trustee without being chartered by the banking regulators. And so we've got a chicken and egg because we want to close those transactions, and one of the footnotes that will be added to the financial statements will explain the charter's been issued, these transactions in a subsequent event have closed, representing our first year business. Now, when we do that, many of the largest clients want to see your financial statements. So our clients have, right now, the first year of forecasted loans to be made by us are in escrow, and all of those clients have received those financial statements for closing. And so they've signed off on it, even though Grant Thornton hasn't signed the audit opinion on the front. Procedures are done. Once a charter is issued, we close those transactions. Grant Thornton wraps up their final management authorization for signing them. That takes about 2 weeks, and the audit would be issued. The final audit would be issued. But nothing will change but a subsequent event note saying that we have the final charter and closed our first year of business in a subsequent event.
Thank you. Follow-up question to that. So we heard from the revisor's office that the legislative intent was that that permanent charter would be issued once all of those requirements are met. So am I to understand correctly, if we don't get you your permanent charter by the end of the year, we really stand to lose out on about, looks like $6.5 million in new economic growth contributions, and then the $9 million that's sitting there waiting So a total, the rural Kansas stands to lose on $15.5 million of economic growth contributions if we don't get you your final charter as required by law on December 31st. Is that correct?
Yes, yes.
Thank you, Mr. Chairman.
Senator Masterson?
Thank you, Mr. Chairman. So just to make sure, this is obviously an issue or terminology is an issue. I can't remember who said it, but sometimes you use the same terms that don't mean the same thing. So I want to make sure I understand what we are talking about. And so I'm going to describe to you what my anticipation is, or what my understanding, and certainly was the legislative intent from my perspective. I think it's the speakers and the governors and the conversations we had. So the question, that's why I asked my original question, that commencement of these transactions is synonymous with permanent charter. So how we use the language there. So it is my understanding, and it was the intention that, so on the way the bill reads, on December 31st, that is the earlier of the dates, you are now authorized December 31st to commence this activity, right? The FidFin transactions, the custodial services, and so your charter is issued. But we are still within the pilot program because you're the pilot person. So you've been chartered, you're transacting now. We don't have this disconnect of, I can't audit a transaction that hasn't even been authorized to transact. And so now you're chartered, you're transacting. The bank commissioner and his group is now finishing up what it means to do that. They've got some suggestions for changes that'll be evaluated in the session. And then the pilot program ends when it's authorized for the industry, right? This has come to fruition, that we've bounced back and forth with you and have made this comfortable for the commissioner's office to release it to the industry. I want to make sure that my understanding is on December 31st, according to this bill, and I know we've got this subsection D, but we've got some date problems there because we're not even back to session until the 10th. But according to this bill, the earlier date is December 31st, and you will be issued your charter or able to commence, whichever way you want to draw your semantics. But we're still in the pilot program as we work with you. Is that your
That
understanding?
is our understanding. Yep. During the process in the committee and the passage and signing of the law, that's our understanding.
Thank you. That's my understanding. Thank you.
My question would be, the bill allows for the commissioner to ask for an extension of up to 6 months. So would that extension up to 6 months move December 31st out to possibly June 30th? Not have to be, but I mean, is not that also in the legislation about the allowing a commissioner to do
The
that?
intent on that was, when the bill was written, is if we didn't have Ts crossed and Is dotted in every area. The one area that we don't have, and the bill does not require audited financials. Many de novo institutions do not provide audited financials. They provide draft forecasts and projections. So we believe that we have complied with the financial delivery in the delivery of our management financials and our full financials with footnotes that have gone through the testing process with Grant Thornton. The only remaining item would be the background checks that would be required to be completed. There are multiple different avenues to complete background checks that do not require the FBI to be part of it. Texas follows a different avenue. All of our directors and senior management have been, within the last 12 months, through full formal background checks by the Texas Department of Banking and by the Bermuda Monetary Authority, who does a global international evaluation as well, using resources from the United Kingdom. So we've been thoroughly vetted on both sides. I do believe that most of senior management, or several of us, at least Derek and I, our reports are back from the FBI and in the hands of the OSBC in particular. So that is really the only one on the background check, and there are different alternatives in order to comply with that. There would be nothing else open to suggest that we need an extension for the delivery of our charter. The continuation of the pilot program continues on, where we work on legislative potential adjustments and so forth on into the new legislative year.
Mr. Chair, may I?
Yes.
Thank you, Mr. Chair. Hey, Brett, I appreciate your vision for the state of Kansas, as I did during the hearings. I thought it came through again today. This is Senator Pittman. I got two questions for you. One was I got a little confused up front. I think it was your maybe the president had mentioned that we had anticipated about, what was it, 260 or $300 million of opportunity, and it was threefold that at this point in time. You haven't actually closed on that business because you don't have a charter yet, or was I mistaken? Was that just in general and inside of your market space, or was that specifically for the Kansas taffy?
That's for our business. So I'll repeat what we experienced. We call it a pipeline when people come in and submit an application for liquidity. We've had $1.8 billion of asset submissions for liquidity from beneficent. Typically, our experience is only 30% of the submissions will pass the credit underwriting process and move to documentation and closing. And so what we did first is we processed $750 million of that pipeline. There's still $1 billion that has not been processed through underwriting. Imagine, it's drinking from a fire hose that came in. And so of that $750 million potential loans, $260 million did pass through, and they are in escrow that breaks on December 31 if it does not close. And that then will allow them to go to other sources for liquidity. So our projections that we submitted in the middle of the year as part of our application included $260 million of closed transactions for 2022. We knew the pent-up demand, but we did not expect it to roll in quite rapidly. And one of the reasons it rolled in, Senator Pittman, is we started in September hosting conferences where participants of our industry came in. And this speaks really to Representative Finnety's comments early on in the meeting. We want to educate the industry, other participants like ours, to prepare and to watch us, watch what's happening, watch sessions like this right now, so that when the commissioner does determine we're ready to open to the industry, we have a lineup of quality institutions to come in. So we've been hosting about 15 institutions every 3 weeks and explaining the TEFI bill. It's been 24-hour sessions explaining how it works and so forth. That led, though, to building the pipeline much more rapid than we expected, and that $1.8 billion of asset submissions coming in. So the good news is by the end of this year, we had actually closed our 2022 business. And as the team at Beneficient looks into the remaining pipeline and what could close and what will enter the pipeline in 2022, we would expect 2022 to actually probably be closer to $500 billion in loans on the books. So by the end of
500 million, right? Not billion.
500 million. Yeah. By the end of 2022, our projection showed 260 million. I believe we'll be close to 750 million in the processing of these applications.
And will all that flow through the Kansas TEFI organization?
Yes.
Not necessarily, not outside through another branch or the three different, not through other means. It's going to all be funneled through.
Correct.
I guess funnel, not a great word, but it's all going to go through the Kansas TEFI.
That's correct.
Okay. The second question I had, Mr. Chair, we had a couple of organizations, even inside of the Unemployment Modernization Group. We had a request by some of the auditors to basically red act and only have an executive session, any kind of findings, which, we're trying to deal with the balance of transparency and the need for competitive secrets. When you went through the process with the regulatory agency, are you finding that you need to have more secrecy, or how do you approach the need for your competitive secrets to stay safe, and then the need of the regulatory agency as a pilot participant to really go through your books and make sure the public is comfortable with the way things are going? How are you managing that? Are you happy with the way that's working, and do you need any adjustments from your perspective?
Alan, you want to visit about this?
Okay, if I understand the question, it's, and this is Alan talking, but if I understand the question is there some concern on our part about sharing work product, trade secrets and such with the state banking department? Is that correct?
That's right. Given that you're the pilot, you're the only one in the pilot. There's a lot of scrutiny on you and how you account for things and how your practice is. And since it is new, and I know the regulatory agency wants to know a lot more about how things are going. Do you feel that you're overexposed, or do you need more coverage, or do you feel pretty comfortable with the way things have gone?
Thus far, what we've seen, and I'm going to tell you, I've got 40 years experience working with the state bank department. I've never, ever had a situation where I felt like they were, quote, talking out of school. And I think as a matter of law and regulation, the work product that we send to them to help them understand our business is confidential, and they don't disclose it. They may not disclose it. And I've never, ever seen in my experience where they were sharing that with anyone other than the intended people, that they had to work with.
And I'll add one more thing, Senator Pittman. Most of our business, when we are bringing in clients, we're transparent to the clients as to how the business works. So most of the information about how the company operates, our underwriting procedures, our documentation and so forth is provided to the customer. So it's in the general public overall. For those items we're concerned about, we protect our intellectual property with a series of copyrights and patents at the U.S. Patent Office. So Beneficient in particular has 8 U.S. patents pending on certain elements of our underwriting system, on certain of our computer processing systems, and on the documentation that we use for our products. So we get pretty good confidence that our patents help to protect the intellectual property development that we have. We have 2 copyrights. One copyright covers, that's been issued, they're not pending, but one copyright covers the computer program system, the actual software system that our developers, Beneficient has 35 full-time computer programmers, programming in 16 different languages, and each month we update that copyright. So we're pretty comfortable that we take efforts to protect the IP that we've created. And that allows us then to be a little more transparent with our customers in particular, well, as transparent as they want us to be on how we operate and what we do.
That's good to hear. Glad to hear it. And make sure you keep all those computer systems really nice and secure. I don't want any breaches here in the state of Kansas, right? Thank you.
Representative Owens?
Thank you, Mr. Chairman, for allowing me to speak a second time. I was perusing through some of these recommended changes by the State Banking Commissioner's Office that we didn't specifically touch on. Certainly needs further scrutiny, but looking specifically at Section 25F, the Commissioner is recommending that it complete a regulatory examination of Beneficient's fiduciary financial institution, and then to resubmit the entire application process all over again to convert it to a full charter. So their suggestion, as I'm understanding this, is you guys went through the entire process. They then expect you to do some book of business without a permanent charter and then resubmit the application process all over again that you guys just spent 6 months doing. I guess my first question is, can a Kansas TEFI even consummate business with a conditional charter without it being a permanent charter? Would anybody even trust that type of an institution without a permanent charter?
The answer is no. When a customer signs a form, they're signing the product form that appoints Beneficient permanently for the charter. They are represented by counsel too, and they're not going to sign a contract that has any risk whatsoever that you don't hold a final contract. So we would break escrow here at the end of the year on the assets that we had. I also believe that it would severely impact the credibility of specifically Beneficient and also Kansas on opening up this to the industry, because many of the participants that are in the pipeline now are some of your blue chip customers across the United States. We need to make a good showing. Furthermore, there's no state, and the OCC does not authorize companies anywhere to operate temporarily or conditionally as a trustee over assets for parties. So this would be very unusual to happen. And it would be detrimental to the closing of the business we have in hand.
It sounds like, if I may, it sounds like it would be impossible for it.
It is. It's almost like selling a car and telling the fella you can't put gas in it for 6 months.
Okay. Thank you for the clarifications.
Any other questions for Beneficient? Okay, thanks. We'll go for questions for the Bank Commissioner's Office. Representative Hoheisel.
Thank you, Mr. Chairman. Thank you for being here today, Mr. Commissioner. You said that it may be necessary for OSBC to extend the time in which the applicant can begin the pilot program and commence transactions pursuant to Section 25D of the Act. When do you foresee yourself making that determination?
I would hope within the next week and a half or so, certainly before the holidays.
Okay, thank you. Thank you, Mr. Chair.
You had a question for the Commissioner?
Yes, I do. Welcome today, Mr. Commissioner. My question is, like I said, this probably end up being a great success. However, I was wondering if there happens to be a consumer complaint, do you all already have a procedure on how you're going to be able to process that? And could you share it with us?
We have procedures in place for consumer complaints as they deal with banks or Kansas state chartered banks or Kansas trust companies. I presume that the same processes would apply to a TEFI if we received a consumer complaint there.
So would that be a phone call from someone, then it goes in front of a board of directors, or what does that process look like?
We are not a ruling on the validity or invalidity of a consumer complaint. We are more a mediator as to here's each side and work with the parties to try to resolve that way.
Senator Masterson.
Thank you, Mr. Chairman. So I just want to make sure we're not wasting time on a conversation we don't need to have, because I don't even understand necessarily why we're talking about not moving forward on 1230. Is your intention not to, to try to use the concept of D there, or are we going to let the pilot program move forward?
Absolutely not. We hope that we can accomplish those two things. As I mentioned, this background check issue has been going on for several months. We didn't get the financial statements until December 1st, so we haven't had any opportunity to look at those, and those are managerial financial statements. I don't think we've seen the Grant Thornton drafts otherwise.
So it's your intention, Mr. Commissioner, that, now, the background checks, them having obviously been checked out in other ways, if that's a delay from the KBI side, does that affect you? I mean, if those don't come back by 12/31, you're anticipating doing that on that alone if they don't respond?
We're looking at other options that would meet the standard that's set for background checks for de novos or new entities and that sort of thing. Have explored a couple of those that have promise, but they're not thorough, as thorough as a background would be from a law enforcement agency.
Okay, so then I think what I'm hearing is we probably do need to have this conversation, because there is the possibility, even though we have some concerns there. So I guess my next layer, because it feels like you made the comments, and I don't know where they came from, maybe that was the House discussion, building a plane while it's flying. But it looks to me, they've not even been authorized to transact, so nothing has left the ground. You're still building the plane on the ground. You got to get something in the air, right, to be able to audit. So isn't that why, and maybe I misunderstood, wasn't there $1 million in this deal that was put towards your office to help build this plane on the ground? What has that been spent on?
We've hired staff who are exclusively focused on the TEFI. We've hired outside legal counsel who has helped draft rules and regs and reviewed that sort of thing. And we still have a sizable surplus.
So, which is good. So we do have, then you've got the staff in place. So I guess I'm struggling then from what I've been presented today to understand for this pilot purpose, what the risk, or why risk, maybe is a better question than what's the risk. Why risk not transacting what's already in the pipeline, having the ability then to audit the actual transactions? What are these reasons that you would anticipate identifying? Not to mention, we've got some timing issues in this, just the way it's written. December 31st is going to come and go. And according to this, they get authorized. You may submit to our committees, and our committees don't even have the authority, they don't even meet until January 10th. 1231's come and gone, shall be authorized by the act. You may do something, but if you submit to committees that don't even have the ability to exist, because it doesn't say to the chairperson, it says to the committees, to both of them, which they can't even receive a report before January 1st, not even before January 10th. So there's timing issues, number one, but even that aside, why would we even consider risking? I've heard nothing here. What are those reasons we would contemplate why you would not go ahead and let the act move forward and authorize I'm confused.
First off, they may not commence FIDFIN transactions until the earlier of December 31st or the date that we adopt rules and regs. I mentioned in my testimony that we have received the comments from third-party counsel and that we expect by the middle of next week to have those rules and regs in place. So if that is an accurate summation of the rules and regs being implemented, we beat December 31st date. Second, I'm reminded of the adage, trust but verify. So we have an extreme amount of trust for this applicant, but we're obligated by our industry accepted standards to verify. So that's why we've been asking for financial statements and that sort of thing. We drafted the application based on the law that the legislature gave us. There was no application prior to us drafting that. Consistent with applications for banks and trust companies, we ask for financial statements. For an operating entity, we ask for historical statements. For a de novo, we ask for pro forma statements. To verify, we needed to determine what this company is going to look like from a financial perspective. This company, as you've heard today, is going to grow tremendously fast in a market that has unfathomable numbers for a brand new entity. So to take those actions without verifying, making certain that there's the capital adequacy, making certain that there's the internal routines and controls designed to manage the growth of the company is all part of what we're charged with, in my opinion.
So I think that this is good to, right? You may actually authorize them before 12/31.
We've wanted to authorize them.
Yeah, right. And that's what I'm hearing is they're then your anticipation is to allow them to operate so you can then verify what they are doing.
Correct, and that's my comments, that we think that we could conduct an examination, which we do for new new bank or new trust company, we examine opening day business. I think it's going to take a remarkably short period of time compared to a traditional bank examination schedule to be able to do this within 12 weeks based on the size and of building that book of business. So I would hope that we could get this done well before that 12-week best guess that I see.
12 weeks is way different than December 31st, though.
We're talking
I
about
think
two separate things, though. We're talking about the ability to do FIDFIN transactions.
So they get authorized 12/31, and then you got 12
And
weeks.
and then when they build a book of business, we can go in and examine that book of business, but compliant to the HB 2074, not a traditional safety and soundness examination because of the
Thank you for
limits.
that clarification. And on, I mean, just safety valve purposes, if something egregious were to pop up, that basically everything's revoked at that point, right? Operations, you can revoke.
That is within the commissioner's power.
Just like, okay, thank you.
Representative Owens?
Thank you very much, Mr. Chairman. And thanks to President Masterson for a lot of the clarification. It clarified a few things I wanted to bring up. I do want to clarify, though, because we were talking about this 12 weeks, and you mentioned what's called a formal charter. Is a formal charter the same thing as what we're referring to as a permanent charter?
Yes.
Okay, so is it safe to say that based on the conversations that we've heard, this section 25F, as well as this recommendation that you need 12 weeks to examine business prior to issuing that formal charter, those recommendations can be removed at this point?
We would anticipate that during that 12-week period, that would be part of the pilot program that demonstrates the ability to conduct the transactions, book the business, and that sort of thing. So that's maybe a technical clarification between where that period comes in play. And please don't consider the 12 weeks as an absolute. If we could do it in 6 or 7 weeks, fine. But if they don't book the business for 20 weeks, we still don't have anything to look at.
But we heard that they can't book the business, period, without the permanent charter in place.
It simply says in the earlier, that they can do FIDFIN transactions until the earlier of December 31 or our granting the rules and regs. So they could do the transactions, in my interpretation, upon the issuance of the rules and regs, if that comes before December 31st, which is our intent.
Right. I just want to make sure that from a semantics perspective, right? You're talking about issuing rules and regs. I'm talking about issuing a permanent, solid charter. Because what we heard from them is without that permanent, solid charter, you can have all the rules and regs you want. People aren't going to come do business with you because their attorneys are going to advise them not to because they don't have a permanent charter. So that's what I want to clarify, because 25F, as well as this examination prior to a formal charter process, you will never have transactions unless you have a permanent charter first.
I think if we can conduct an examination based on the transactions, I cannot speak to when they decide that they can issue or could provide transactions that are compliant with their rules and or other rules. But in order to do an examination, we have to have something to look at. And this anticipates a pilot program for them to get started and to conduct the transactions that will ultimately be examined. So I would have to defer to others before I could tell you absolutely that they can or cannot do transactions under a conditional charter that permits the pilot program. And I'll be happy to research that and get back to you.
Mr. Chair, if I could comment on that.
Yes, please.
Thank you. Representative Owens brings up a point, but I don't think the bank commissioner is in a position to go against the structure that we put in place. It was very clearly laid out that we have a pilot. It starts on 12/31 by default, unless they get these rules and regs in place, and then they can start doing these FID/FINs. I don't think the pilot participant had any issue with that, and they have $260 million worth of business ready to go. And they're going to have a bunch of transaction according to them. I don't see why we're discussing this at this point. It seems as though we've got a pilot ready to go. We've got an understanding that the banking commissioner and his folks are going to get in there. They've got the people to examine it and evaluate it. He thinks it's going to be 6 weeks or 12 weeks. He thinks that it sounds like the business is there. And then after that's successful, they can get the full-blown charter, and and then we can start introducing other folks into the industry, into Kansas. I don't understand what the issue is here, because it seems like as though that was already laid out in the bill, and we have no issues being expressed from the pilot participant on this.
Mr. Chairman, may I invite Staff Counsel Matt Shoger to further address 25F proposed?
Yes.
Mr. Chairman, members of the committee, my name is Matt Shoger. I'm a staff attorney with the Office of the State Bank Commissioner. The question is about the charter process and our proposed subsection F, the first half of which we believe simply clarifies the existing process under HB 2074. Section 2 of HB 2074 states, except as provided in Section 25, which is the section about the conditional charter, the State Banking Board shall not approve any application until the beneficent conditional charter has been converted to a full charter and the commissioner has completed a regulatory examination. So we know from that sentence that there must be a way for the conditional charter to be converted to a full charter. There are no express provisions within the bill, within the TEFI Act, that state how that conversion will take place. It was in an earlier House bill a provision that, separately from the provision that stated that the TEFI can begin FID/FIN transactions at a particular date, there was a separate provision that stated that the charter would automatically convert to a final charter along those same timeframes. So at the same time they'd be able to operate, they would receive the final charter. That provision was not included in HB 2074 in the amendments that came into conference committee. And then the House delegates to the committee were the ones who brought those conditional charter provisions to the conference committee. And they spoke at length on the House floor regarding what those provisions meant, regarding what is a conditional charter, regarding when does it become a final charter, and when does the pilot program end. There's statements by both Chairman Kelly and Ranking Member Zhu, and I will read some of those statements. We developed a conditional charter so that beneficent would not be operating under a full charter until the rules and regs are developed and that one exam was completed, so they can open up really for full operation. These remarks right now I'm reading are from Chairman Kelly. I'm going to read them a little bit out of order. They're thematically related, but not necessarily chronological here. They will be operating under a conditional charter. So that means that operating is not the same as having a full charter, because they will be operating under a conditional charter. A successful exam from the Office of the State Bank Commissioner will take place before the full charter is issued. When they officially apply for a charter through the Office of the State Bank Commissioner, that's when the investigation begins, and when that's complete and they've made their determination, that's when they will issue a charter that says that they can actually operate at full scale in Kansas. The State Bank Commissioner won't sign off on it, actually, until they develop the rules and regs and go through the first exam. At that point, you can say that the Bank Commissioner, Office of the State Bank Commissioner, has signed off on it when they issue the traditional charter. So that's one of the guardrails on it. That it has to be tested, and he actually has the comfort level, and his examiners do, that they sign off and they issue the charter, and that would be the kickoff that says that we're out of the pilot and we're into an operating program. This company will be vetted by the Office of the State Bank Commissioner when they apply for their charter, and they will have to meet the guidelines and meet the financial conditions of a company to have a charter issued to them. And that means, by the way, that we're under Section 2, not Section 25, because there aren't financial conditions of a company that have to be met under Section 25 for the conditional charter. So that is under Section 2 for the final charter. The vetting will be done when the application is made and we officially have that company wanting to do business in Kansas. We will vet them. The State Bank Commissioner will vet them, and if he feels they pass the test, he will issue the charter, which puts kind of the state's seal that this is a financially stable company to be able to come in and operate in the state of Kansas. The State Bank Commissioner is not going to issue the charter until they're comfortable with the company, the financials, and what they want to do. Chairman Kelly also referred to it as a normal charter process, or the process for the final charter. Ranking Member Zhu stated, the pilot program is also severable by the Office of the State Bank Commissioner at any point if they feel like it's not appropriate. Another statement from Ranking Member Zhu, the oversight that we built in will allow us to take that risk. I'll read one more statement from Chairman Kelly, and then I will move to our draft and how we believe it clarifies the existing process. If it doesn't work, then the Bank Commissioner does not issue the operating traditional charter, and we either continue to work on it or no charters are issued until he's satisfied that we've got the proper controls in place. So now I'm going to turn to our proposed Section 25F. There are 4 sentences in this paragraph. The first 2, we believe, clarify the existing process, and the second half, we believe, fills in some gaps that are not currently addressed in the bill, in the TEFI Act. So I'll also state that the only way in the TEFI Act to receive a final charter, again, there are no provisions expressly stating how the conversion will take place, but the only way to receive a final charter in the TEFI Act is through an application under Section 2. Is the only way that there is in the bill. So I will read sentences here. I'll summarize a little bit as I read. After the Commissioner has completed a regulatory examination of the beneficent TEFI, the beneficent TEFI may submit an application under Section 2, which shall be considered as an application to convert its conditional charter to a full charter. If this application is granted, the beneficent conditional charter shall be converted to a full charter, and the pilot program ends, and other TEFIs can come into the state. We believe that reflects both the text of the statute and the statements by the carriers of the amendments that we're interpreting here on the House floor to the rest of the legislature. We believe those 2 sentences are not a change from existing law, but simply a clarification. The next 2 sentences there, if the application is not granted, the beneficent TEFI may resubmit its application after addressing any deficiencies and shall not be charged any additional application fees. So this is, so if they have to submit an application to receive the final charter, which we believe is the process under HB 2074, what happens if that application is denied? That's not addressed in the bill, or in the TEFI Act. So this addresses that. They can resubmit it as many times as they need to. But it being a conditional charter and them operating under a conditional charter, the conditional charter, just by common sense, should not last forever. And the pilot program, being a pilot program, would not last forever. So this last sentence simply puts an end date on the pilot program. So if the beneficial conditional charter is not converted to a full charter before 6 months have passed after a second regulatory exam, so that's the deadline then, so 6 months after a second regulatory exam, and no conversion application remains pending, so they could get the application in the day before the deadline, and it would essentially extend as long as that application is pending. The Commissioner would then revoke the beneficial conditional charter, and the pilot program would end, and no more TEFIs would come into the state, because at that point, the pilot program would be deemed to have essentially failed, which hopefully does not happen. We hope that the TEFI program is as successful as anyone else does. I believe, so that hopefully clarifies our understanding of the charter process. I can stand for questions on that or any other questions on the bill draft. The Commissioner and General Counsel are also available for questions.
Senator Masterson.
Thank you, Mr. Chairman. That actually does clarify why we were dancing a little bit earlier, right? Because that is the opposite of what I heard from the reviser about the understanding of permanent charter being synonymous with the ability to do business. That is the opposite of what I heard, and certainly the opposite of what I understood to be the legislative intent. And to take in, I understand you're using comments that were made on the floor, but that's not a clean reading. And it's certainly an opinion. And I've learned with all my lawyer friends, everybody has one. And you can put that forward, but that is not the way this reads. And it certainly was not the way it was intended from the perspective on the Senate side. It is intended that that is synonymous and that there is a date. It's not a process. You're now trying to present to us that there was a contemplation of multiple application processes to go through this process. That's not at all what was contemplated. This was meant to go from conditional through the process. On the 31st, it was to be permanent so they could transact business, and then you would audit. And you have the ability to do all that trust and verify in that second half before you let anybody else in the industry in. It seems like this is almost now a strategic contemplation from the commissioner's office to kind of short sheet the process and undermine the process, which was not the legislative intent. That is a 180 from what I understood this to do.
That's not at all our intent. I assume that was the end of your.
Yeah, that would, yeah.
Okay. That's definitely not at all our intent. I remember in law school reading about how, case law on interpreting legislative history has changed over time. Scalia changed it considerably, late Justice Scalia. And I remember two things pretty clearly from that. So one is when the text of the statute is clear and unambiguous, the legislative history is generally irrelevant. Here, we don't have any express provisions.
And that's when it's being litigated, right? We're in court, we're litigating. Those comments come into play. We're not litigating anything here. We understand this to be the process. I'm not saying they're irrelevant, that those comments are irrelevant, but we're not in the court of law.
What I'm saying is that the commissioner, the Office of the State Bank Commissioner, receives its lawful authority and lawful direction from statutes that have gone through the constitutional process of bicameralism and presentment. And we are going to interpret those statutes in light of how courts would interpret them. So because the statute is ambiguous, we do look to legislative history. Generally, in my experience, and I remember from what was said in law school and in my experience looking up legislative history, often spend hours on it and don't find anything on point. We've got almost just a veritable gold mine of what these exact provisions mean. And the second thing I remember from what Justice Scalia has changed about case law regarding legislative history is that some legislative history is more reliable than others. Some people will say that Justice Scalia was always opposed to
I appreciate the history lesson there from your perspective, but the point is what I'm hearing now is it is the bank commissioner's office's intent to short see what we thought was the process. We're going to leave that conditional. Therefore, the transactions can't be made. Therefore, you can't audit the thing and the whole thing collapses. That's what I'm hearing.
Mr. Chair, if I may, I don't interpret this at all like that. I think that the statute was clearly said that there's a conditional charter, and there's nothing wrong with having a conditional charter in place. My colleague is right that there is some, it can seem as though, I heard some of the things that this whole thing would fall apart after two go-rounds with the commissioner, and that causes me a little bit of heartburn. But other than that, there's nothing wrong with having a conditional charter, proceeding with a business, evaluating that thing. And as a pilot program, that's what a pilot program does, is an evaluation stage. And it was billed to the House at least, and I think a little bit into the Senate, that there were going to be safety valves like this put in place. I don't think that this law is, the intent was just to put a full-blown charter in place and let it go whole hog without any, and just have one kind of quick check on it. I think it was a pilot. That's what it was for.
With all due respect, Senator, I don't think you've been listening to the conversation then. I don't know if you got up and went to the restroom. But
no, I've been right here.
The conversation has been around.
Why would you say that?
Because the conditional charter was expressed by the conferees that if you have condition, you don't have transaction.
They said they can do a FIDFIN if they have conditional charter.
No, they said they could not. That's what I'm saying. That's what I think you missed. The answer was you could not. If you have conditional, you cannot complete the transaction. And that the pilot program comes into effect because you have the ability to revoke, you have the ability to audit, you have the ability to verify. I think there's semantics here that are getting in the way of what it means to be permanent or conditional. All I know is that we intended for these transactions to be had on December 31st, that there would be authorized ability to transact. And whether you, however you want to call that, I don't really care. What needs to be in place is the ability for them to have a transaction that is long lasting, period.
Well, with that, I would agree. I would agree that we anticipate that there should be the ability to have FitFin transactions occurring at 12/31 or on the day of the rules and reg. That's for sure. But that the charter itself doesn't need to be issued until after the regulation. But the understanding was that the FitFins could actually go through as transactions starting. That's how a pilot program would start. And I guess if that's what they have said, then I would be in agreement. I don't think they're trying to undermine the process, as you said, but I think I'm in agreement with the fact that, yeah, we need to have the FitFins happening right away.
If I may, we agree with that. They can commence transactions under the conditional charter.
Mr. Chairman, but if the apparent disconnect is the technical authorization under some language and the actual ability to complete the transaction. It sounds like there might be some disconnect there. I want them to actually be able to complete the transaction. I don't want somebody to tell me under a technical term, you should be able to do it. So whatever needs to be in place for those transactions to happen needs to be in place, whatever you want to call it.
2 points, if I may. First, I think we made it clear that transactions can happen upon the issuance of rules or regulations or December 31st, whichever comes first. Okay, we agree there. As to the proposed changes in the reg, that is from section 29F3 that says that we can provide recommendations to this committee for any legislation necessary to implement the provisions. So this is simply a recommendation for this committee to consider. Whatever it does with it, whether it takes it to the session or kills it today, is purely here. We're simply following the provisions that says we can and should provide recommendations to this committee.
Senator Longbine.
Thank you, Mr. Chairman. Three points. I don't know that I've ever heard in a committee talking about a statute, the comments of conferees on either floor. I did carry this bill on the Senate floor. I do have my notes with me today from carrying it on the Senate floor, and oftentimes bills are presented differently to different bodies. I'm not questioning whether those presentations are factual. Some of them may be more succinct than others. I do find it a little bit unusual that we would present testimony concerning comments made on the House floor and not the Senate floor. So I don't know whether the Senate conferees to the conference committee were discounted, or there was not those same similar comments made on the Senate floor. I think if you're going to use those in drafting proposed changes, that both should be considered. Point number two, there seems to have been, I've got confusion in my mind. The legislation appears to be permissive on background checks. This may be something that the revisers can do over lunch if they don't have a definitive answer right now, but I would like some kind of explanation from the revisers on whether FBI fingerprint checks are required or whether that is more of a normal occurrence that happens within state government. I read it as a background check will be done. I'm glad to hear that you are looking for alternatives that maybe those could be done by year end, because I don't have a lot of confidence in the timing of the KBI and the FBI at this point. The main thing I want explanation from Mr. Herndon is we had a tremendous amount of discussion in my committee on the Senate side. I know the House had a lot of, I'm going to call it heartburn, We had tremendous amount of discussion in leadership offices and in the conference committee report about a TEFI is not a bank and it is not a trust company and should not be referred to as either one of those. And it was quite likely going to require a different examination process because they are not a bank and they are not a trust company. In your testimony, you refer back to the CAMEL system and you refer back to trust examinations, which I understand the difficulty in trying to apply those to a TEFI. I was under the impression that this time from the end of session to December 31st was the time that you would work with Beneficient and the experts that you were going to hire to develop a new examination standard. What is the progress of that? Or did I completely mess that up?
My comments regarding the CAMEL's ratings for banks and the ratings for trust companies were simply as an illustration, not intended to apply to this applicant or to the TEFI industry in general. That's why I said the examination, other than the federal requirements for bank secrecy and anonymity, those sorts of things, is likely going to be a pass-fail kind of judgment as to the application of Kansas law for this particular.
Okay. I would hope that as we work through the pilot program and as we gain additional knowledge, those rules and regs and examination standards would be developed to be something more comprehensive than a pass-fail, but I understand we've got to walk before we run.
I agree.
I also certainly respect your proposed changes, but I also hope that the Commissioner's office understands that those will be taken up by our individual committees as proposed legislation. We cannot receive or do anything with until January 10th, and that will need to go through the process. So
Understood,
certainly
sir.
look forward to discussing those in our committees in the future.
Understood.
David or Eileen, whoever, on fingerprinting?
Thank you, Mr. Chairman. Yes, on the question on the fingerprinting, the permissive versus mandatory. First of all, in Section 2, I think this has been pointed out a couple times, Section 2F. It's kind of an odd microphone here, but Section 2F, the state banking board may require fingerprinting for officers, directors, or the persons of the TEFI related to the application as deemed necessary by the banking board. And such fingerprints may be submitted to the Kansas Bureau of Investigation and the Federal Bureau of Investigation for the background check. There's also then several statutes for different licensing boards. You got the Board of Nursing, insurance licensure, attorneys, money transmitters, trust companies, trust companies specifically 9801 of the banking code. And those are also have that permissive may language, but in most instances, those have been adopted by those licensing boards and have been done. There are a couple of instances in statute where we specifically say shall. KSA 745607, that's the Law Enforcement Training Center for law enforcement officers, and 748804 for the Gaming Commission. Those are specifically statutorily required, shall take the fingerprints and submit to the background checks. Those others are, again, permissive, as is the case in 2074. However, if they are determined to, if the licensing board or agency does that, the fingerprints would be through KBI and FBI. I mean, nobody else is doing that fingerprint analysis. I mean, so that would be the clarification.
Well, yeah, one quick, and then we'll break for lunch and come back and clear up anything else?
Thank you, Mr. Chairman. Just one last question that kind of popped into my mind for the commissioner or one of his representatives. What is the risk, based on what we know today, based on the fingerprints missing, knowing that they've been done in other states, knowing that you have full authority to take this charter away if something bad or whatever meets your level of revocation, what risk does the state have, does anybody have in giving them their full charter by December 31st and allowing them to transact business and you guys to fulfill then your requirement to review that business? What risk is there to the state that leads us to want to put that permanent charter on hold for any period of time beyond December 31st?
Because this is the first and only state to so far have anything, the best answer that I might provide is reputational risk. I cannot identify any financial risk to the state or to the citizens of the state. I cannot identify any of the other reasonably accepted risks that something starts, but with a new, never tried before, I default to a reputational risk. Reputational risk for the industry, for the state, for the office of the State Bank Commissioner, and not necessarily in that order.
Thank you.
Okay, we're just about 6 minutes past 12:45, so let's break for lunch. Any additional questions or any one will come back, we'll kind of go back and forth after lunch to make sure we get everything addressed as we head towards our 2:30 adjournment. So for right now, we will be on break until 1:50. That'll give us an hour. intended. But we'll want to go and finish up to put us in position to adjourn as close to the designated time as possible. In this afternoon session, what I think we'd like to do, if there's other questions, we can have them, but kind of maybe allow each beneficent and the bank commissioner's office to make comments on what they've heard and answer questions in more detail than maybe they were able to in the discussion. And the discussion pretty much seems to be around the word conditional and the fact that I think the commissioner's office is allowing trust to be open under a conditional, but that's the sticking point. So would like to begin, and Mr. Hepner, I know that you had earlier wanted to make a comment, and if you would like to start out, that would be great, or anyone else you want to designate. The
There. Just for clarification, from the company's perspective and understanding, we were to submit a final application. We were to go through an examination during the period beginning July 1st of this year. And I think there's just a misunderstanding of that. Then it's supposed to be repeated and done all over again. It doesn't call for two of that in the legislation. And had we known that that is the way that OSBC would interpret it, the lawyer would interpret it, we would have been very vocal during the legislative process at the beginning of the year. We submitted a final full application on June 11 of this year. We submitted our financial statements with complete footnotes. In addition, we submitted management financial statements on top of those financial statements. The financial statements we submitted were on November 16 with complete footnotes, with the exception being we informed the OSBC in a meeting in person and in email correspondence to the chief examiner for the TEFIs that there would be an additional footnote on subsequent events upon the time in which we close in this escrowed client amount and the issuance of the charter, and then the full financial statements with footnotes would revert back to the company's auditors at Grant Thornton for final signature from them. And I was on our phone with our chief financial officer over the lunch hour, and that is all teed up to do and go with Grant Thornton as soon as final charter is issued. So it has been repeated by the commissioner that they have not received our financial statements with footnotes. That was delivered on November 16 under cover of an email, and also dropped into the system, the documentation system, where both the OSBC and beneficent drop documents to share between each other. We completely believe that we've completed the examination process. We have submitted well over 100 documents, 2,500 pages of documents, like any new institution would do. Our books and records have been open. Prior transactions and model transactions have been reviewed. Form documents have been done. We've gone through the examination process, and we clearly did not have any understanding that there would be a subsequent examination next year before issuance of the final charter at all. Finally, our understanding was upon the issuance of the final charter, we closed business and so forth, and the commissioner's office would then complete another round of examinations to further make sure that we understand the business and so forth, and what business we have closed prior to opening the TEFIs to the industry overall. So we really thought that that second examination is as a finally chartered operating entity that allows you to close business. Now, the chicken and egg problem that we have is that clients will not do business, will not sign this escrow, and in fact, our escrows breach and have to be released on December 31 if we don't have the charter on this first round of closings of $260 million of loans. They won't do business and finalize it if they do not have the representation from us and auditable evidence from us that we are a final chartered entity, not a permanent charter, because they are advised by fiduciaries, which are financial institutions, registered investment advisors and so forth, and the fiduciaries require that representation from the company. Otherwise, there is a high degree of risk that they're not willing to assume. They assess it as a high degree of risk that a final charter may not be assumed, and they don't want the word may. They want to hear it has been in order to close it. I really liken it to the concept that I'm not aware of any state, I'm not aware of any bank who's allowed to take FDIC-insured deposits for a period of time without having a full final bank charter until they're examined next. That doesn't happen. Or any state that allows a company to operate as a trustee. Every state requires a company be fully chartered under their laws, not provisionally chartered, but fully chartered. You cannot operate under a provisional charter as a trustee. You have to have a final charter, and a conditional charter is akin to a provisional charter. There's no state in the nation, and the national OCC doesn't permit companies to serve as trustees, as fiduciaries, under any type of a conditional or provisional charter without a full final issued charter. That doesn't exist in this country. And our products require us to serve as the trustee, as the fiduciary of them. So we're not able to close the business without it. So I wanted to clarify a handful of points from the company's viewpoint. And then Jeff King would like to get up, and he's got a number of other items to tack on. He's more articulate than me.
Thank you, Mr. Chairman. Jeff King of Sage Law, appearing as outside counsel for Beneficient. I am most certainly not more articulate than Brad. Please don't hold me to that standard. But I did want to frame, I think, one aspect of this discussion that may have gotten lost in some of the technical statements that's been made earlier. I think one very true statement was made that, Mr. President, you pointed out as well. A lot of times we're talking about the same terms, but different people are giving those terms different meanings. And I think that's where some of the confusion lies here. Particularly, Section 2, I don't think anyone has any disagreement on, at least at this point, really looking at Section 25 as it constructs the pilot program, as that pilot program is structured solely for Beneficient. And there are a couple things in the OSBC's interpretation and proposal to this that I find troubling from a practical perspective, and I know in the legislative debate on this subject the last year would seem to run contrary to that. Under the interpretation of their interpretation of Section 25 and then their proposal in subsection F, you would have a pilot program that would last approximately 12 weeks. You would have the pilot program start December 31st. You've heard testimony there'd be 10 to 12 weeks, and then an examination would occur, and then the pilot program would cease, final charter would issue, and you would fall under Section 2. And obviously, those of you in the room know much better than I do, but I have never heard of a pilot program for a new entity that has no precedent anywhere in the nation lasting 12 weeks. I'm not sure what this body would learn. I'm not sure what OSBC would learn in January, February, and March that we don't know right now. I know in other pilots that the legislature has run in far less complex things than a TEFI, pilot programs will go a year, 18 months, 2 years, to give a full chance for the regulatory body to examine the actual occurrences on the ground, for this committee to then take those learnings in future sessions as the statute envisions and apply those learnings to potential changes if necessary in the future. The 12-week pilot, I'm not sure what it would accomplish. From a practical standpoint, the legislative proposal from OSBC in 25 Section F would require either a feat of incredible legislative speed or would be absolutely moot. Because essentially, this design of the 12-week pilot, OSBC is asking you to approve in a new statute when that pilot would effectively terminate sometime in March or April, which my guess is this legislative body, even if working very quickly, wouldn't have that statute approved even until March or April. So stepping back from the semantics to, I think, the practical aspect of what we're dealing with here. Beneficient acknowledges that it would be operating under Section 25 in a pilot program, that it would be represented as a pilot program, that it would be examined in the future under a pilot program, that this body would evaluate what it has done and consider any proposed future legislative changes in the interim and standing committees, given its work as a pilot program. No one is arguing that at all. I think everyone agrees on that point. It's literally the semantic point of, are you operating under a full charter in a pilot program or a conditional charter in a pilot program? The practical effect of OSBC's power, of this legislative body's oversight power, of what legally this program looks like, the use of conditional or ordinary pilot charter makes absolutely no difference. But we are operating in a brand new world that I know this committee readily understands, but I would guess there are 50 people in the state of Kansas that understand what is going on here. The difference between those two terms matters enormously when you get outside that group that understands. And for this program to be successful, like everyone here wants it to be, we have to inspire confidence nationally and globally in what is going on. And that semantic difference, while immaterial legally and immaterial to this committee, could be the difference between operative success and failure. And so what I would ask, and I think Beneficient is asking from this body, is not to change the construction of the pilot program in the statute. Beneficient is very happy to operate as such, but to make it clear that Beneficient is operating under a standard charter through a pilot program, not a conditional charter, because the success of their venture may depend on that distinction.
Jeff, question for you. Sure. So, not sure that I understand everything that you said, but as far as the pilot and all, but would the thought, is what you said or what maybe I heard and you didn't say, is that you would run December 31st, it would be a full operating charter, and the pilot would run for longer than 12 weeks, and an evaluation would be done on whenever a first scheduled exam would be to determine whether it's open to other companies at that time. So you would let it operate under a full charter, have a point in time designated that the pilot would be evaluated, and it's no longer a pilot, and it's opened up for others to come in, other companies to come in.
That is correct, Mr. Chairman. I think you articulated it much better than I did. That's exactly it.
So is there, in the discussions, is the pilot's length of time based on, because there was an examination in there, is the pilot's length of time based on when, rather than 12 weeks when you would agree that you probably wouldn't see a lot of the full operation, you'd see a startup and maybe not operating. When you got to a point in time, you'd do a normal bank, trust company evaluation, whatever that period it is, and it passes, that would end the pilot.
That would be my understanding, Mr. Chairman. I know an original versions of this bill that became the TEFI law had a definitive length for the pilot in. And all the members of this committee would know far better than I. But my understanding is that was removed during deliberations out of a desire to avoid an artificial duration of the pilot. And trusting that OSBC, this body, both as a standing and joint committee, would be better situated than an artificial deadline to know when the time was right to open it up to the entire industry. And I can't fathom that that time is going to be 12 weeks in. And by eliminating the semantic distinction between conditional and final, it allows that duration to be determined organically by this committee and the OSBC.
So in a normal pilot at, whether it's 12 months, 18 months, or 2 years, you reach a point in time, you say, yep, it works, let's go with it. Or you say, nope, it doesn't work, and we're going to shut it down. What do you visualize there?
I would visualize that this committee, that with the investment of time and resources, that not just this committee, but the entire legislature, the governor's office, and others have put in the bill, I think the most, if it's not just everything's going well, full speed ahead, I think the most likely option is not just shut it down, but is what modifications does the legislature need to make to give this project a better chance of success, which is why personally I had envisioned it in conversations with others at Beneficient that this may be a subject that is considered a great deal by, say, the 2024 legislature, or a little bit by 2023 and leading up towards 2024, depending on how the pilot goes. I very much want to avoid a situation where we think it's thumbs up or thumbs down, but I think it's more of a situation where we take learnings, we revisit, and we see what that looks like. But so that is, I think, the more likely of the options. But certainly the chairman expresses one that I think is unlikely, but is possible.
Okay, I mean, you have always a possibility, not what anyone that starts the pilot wants to happen.
I mean, anyone that holds a final charter still has the possibility that OSBC will engage in regulatory action and find that that charter needs to be further reviewed for any traditional bank. And certainly there's no exception to that here, and everyone recognizes that. I think there is a certainty with a full pilot program that is recognized as operating just like a traditional charter would, that will give some solace to prospective investors, prospective clients, to the national industry as a whole.
Mr. Chair, may I?
Sure.
Thank you, Mr. Chair. I'll just make a note, this is Mr. King operating as legal advice to this company. He's by no means an expert in pilots. We know that. It's just another opinion out there. I absolutely, now that I understand the situation, have found myself agreeing with the President of the Senate that, if it requires full-on charter to get these clients to, engage in a fiduciary relationship with our pilot program participant, then absolutely we need to move that and suggest that that's the way to go for 12/31/2021. And agree. What we want is for the FitFin transactions to commence, January 1st, January 2nd, and start building the book of business to allow for that 12-week regulatory review, which is all that is a time length we put in place, or that they're suggesting to put in place to review this so that they can further refine how this thing gets rolled out. I personally don't think we should hold out a pilot program for 2 years. I think that offers I appreciate our pilot participant, but I don't think that we should hold out a first mover advantage for 2 to 3 to 4 years till 2024 for this pilot program to end. I think it's a bit of a, if it is a really great market, we should have at least some other people being able to participate that early on. So I think, 6 months is not an unreasonable time, if not sooner, to finalize a pilot program in this space. But I'm tending to agree now that the company has put testimony out there that, if it's a full charter we need and it's not conditional, and that makes a difference between whether we can actually book business or not, that makes sense. And then it just begs the question of what are we doing with the pilot program? And I think that that's just a matter of reducing the risk to Kansas, allowing us to have the bank commissioners focused on there with some extra resources and to produce the best product that we can for the most progressive legislation that keeps the liability and the risk down for everybody investing in these things. And I think that's the big thing. I happen to agree now with the Senate president's position, but I don't agree that we should hold this thing out for 2 years. That just seems like a long time and a little outside of what I think is practical. Thanks.
Senator Longpine.
Thank you, Mr. Chairman. Mr. King, thank you for your explanation. A couple of thoughts. We are dealing with very sophisticated investors with this instrument. In fact, by definition, they have to be a high net worth, sophisticated investor. Those people and their advisors are not going to invest their money in something that is not permanently chartered. I totally understand when that I would sue an advisor that put me in an investment that was not fully, without disclosing that to me. So I understand December 31 to me is a very important date because I'm assuming that is some tax laws for 2021 rather than 2022 if I am an investor who's trying to get some liquidity or shield some income this tax year. So I think that's an important date. I don't have any problem with the issuance of a permanent charter because I do believe that the bank commissioner has the ability to suspend or revoke a charter or a license of a company based on misrepresentation of financial records or whatever. The commissioner earlier talked about reputational risk. I deal with reputational risk every day. I understand it. I don't want to be in that either. But when I evaluate the reputational risk of the bank commissioner versus the pilot company, if the pilot company were to get their license suspended or the program revoked for a misrepresentation or falsified financial statements or whatever, that reputational risk is much bigger to them than it is to us. So I'm not overly concerned about issuing a permanent charter before an examination or those type of things because we do have a chicken and egg situation. The length of the pilot, as those that have been around me in my legislative career, I believe we need to stay in our lane. And I'm not very comfortable in getting out of our lane. I think when that pilot program ends should be a decision by the regulatory board. But I would also say that I don't want to give Beneficient a 2-year advantage to keep their competitors out of the market. I also don't want to keep the state behind by 2 years of growing this possibility by keeping it in a pilot program for 2 years. So I'm perfectly comfortable with leaving that decision on when that pilot program ends with the banking commissioner when we have not only the company that's in the pilot, but also the commissioner that are comfortable with proper regulation and oversight.
Yes,
Thank you, Mr. Chairman.
Thank you, Senator. Representative Owen.
Thank you. Thank you, Mr. Chairman, and thank you, Mr. King. I think that was a very great explanation. I, too, with the previous senators and others, agree that ensuring that they get their charter timely is incredibly important, not only for the contributions that our state will receive, the benefit thereof, but then also ensuring that these transactions close. I think that the legislation does indicate that once that examination is completed, the rules and regs promulgated, and that first examination is done, then the doors are open to the industry. And I too very much advocate for that, as I believe Beneficient has been very clear that they advocate for additional competition because I believe in their own words, they're one of the smaller players. And I look forward to having conversations with some of the bigger players that are going to come here and further grow this industry. So thank you very much.
And Mr. Chairman, if I briefly may, I agree entirely with all of those comments, and I want to make sure not to have misrepresented anything for myself or for Beneficient. There is no desire, I know, by the company to have any competitive advantage by a prolonged pilot. It's my thought, and what I was trying to articulate is that length should be absolutely organic based on when the OSBC determines that the pilot is ready to progress, not in any rush to a final charter, nor in any delay by artificial means. I agree entirely. Beneficient's ready to compete with the rest of the industry when Kansas is ready to open up.
Right, and I think going back in memory, there was a lot of discussion that usually for some type of new entity, a lot of times 12 months is an exam to look at how things have gone. So, I mean, in my mind, I would have anticipated being any longer than that. But that it gives you enough time to evaluate that it is working or what changes need to be made before you open it up and have any things that aren't working right multiplied, but kind of an ongoing improvement, a tweaking project, if necessary.
I think that's a fair statement.
Any other questions for Jeff King or anyone else before we turn it over and let the banking commissioner? Yes, Representative Poskin.
Thank you, Mr. Chairman. As a first-year legislator, something I hear all the time is unintended consequences. And in committee, we talked quite a bit about being on the leading edge versus being on the bleeding edge. And the guardrails were intended to make sure that we're not on the bleeding edge. And I believe our discussion was around making sure that Beneficient had the opportunity to move forward and to make TEFIs a thing for Kansas. So I'm concerned if we do not give the permanent or the charter that they need to get the investments, that we're going to be left on the dusty ledge when it comes to the first mover advantage. Thank you.
Any other questions? And then we can give the bank commissioner's office ability to respond in any questions that we want to go to them.
Mr. Chair, I would just note on one thing on Mr. King's testimony that he mentioned the legislature can't move very fast, but I'll tell you what, I don't know if you watched while we passed some great legislation in less than a day recently, so we can actually absolutely act as fast as we need to if the issues are at hand.
I will, Mr. Chairman, the record can reflect, I watched as the record that we set in the hard 50 special session for the quickest special session was topped by the legislature this year. So I was well aware of the speed and the good work that the legislature did.
Senator Fagg.
Thank you, Mr. Chairman. Thank you, Mr. King. The only thing that I would add, I agree with all the senators, all the reps here on their thoughts with this. The thing I wanted to add to this is that in the spirit of showing the country that Kansas is open for business, we got a chance here, folks, to show ourselves. And this is a pilot program. We are flying a new airplane. But it's one of these type of things that I think it's time is of the essence, because I'm sure there's other states that's probably looking at this. So this is our turn to show where we come from. Thank you.
Anything else? Thank you, Jeff.
Thank you, Mr.
Very much. And Commissioner, would you like to, and anyone you designate also for any responses?
Thank you, Mr. Chairman. I want to make a couple of points just to be clear. In the OSBC's opinion, the pilot program actually started the day the law became effective. That's the day we issued our first charter. It was conditional, but that's when the pilot program started. We asked for additional information through an application process, an application that we created because one did not exist before that asked for additional information, and that information has been received, some of it timely, some of it not as timely as we'd hoped. For example, the financial statements. We received the unaudited financial statements and the managerial financial statements in the middle of November and on December 1st. Today's December 7th. We need some time to take a look at those. We need to develop our questions, answer that. But we intend to do that. We are working as rapidly as systems and processes and third parties allow us to. We have no intention to stand in front of the progress going forward. Second, we talk a lot about conditional charters, provincial charters, permanent charters. Until this legislation became effective, there was no distinction. You either had a charter or you had no charter. We intend, as rapidly as we can, to issue the charter. Call it permanent, call it forever, I don't care, but we're going to call it the charter. We will additionally examine this TEFI and subsequent TEFIs based on the transactions in their book of business. The 12-week is a very aggressive manner based on our discussions with the applicant as to the number of transactions and the size of those transactions that we would get in to see as quickly as we possibly can. 12 weeks is very aggressive, but this is a very aggressive pro forma financial statement that we're looking at as well. If it turns out that we can do an examination, as I said earlier, in 6 weeks, we'll do it. If it takes 18 weeks, we'll do it. But based on the pro formas, and based on the testimony that we've heard with the size of the business that could go there, if we waited a year before we did an examination, we could be looking at $750 million to $1 billion asset company that hasn't had any regulatory examiner before. Remember, we're the only regulator assigned here. There's no OCC, there's no Federal Reserve, FDIC, or anybody else. It falls to us. So we are taking it seriously, but we are also being as proactive as the legislation and as our time permits. And with permission, I'd like, again, for Staff Attorney Shoger to come forward and make some comments.
Mr. Chairman, members of the committee. My name is Matt Shoger, Staff Attorney at the Office of the State Bank Commissioner. Just had a few comments to make in response to some things that were said. So first, I want to say that a lot of the arguments that have been raised today, the OSBC has never heard before. So to be clear, we provided a detailed legal analysis of the charter process to Beneficient several months ago. I personally walked them through the provisions in the draft bill that we provided, including that section regarding the charter process. The arguments that the points that they presented regarding transactions that won't go through as a result, we've never heard that until today. There are the fact that they believe the charter was to automatically convert. We have not heard that before today. So it's difficult to address all of those arguments because, again, we have not heard those arguments before. The point was raised, there was a suggestion made several times during the discussion today that the pilot program would end when the bank commissioner decided it would end. I just want to point out that the end of the pilot program is defined by statute in Section 2, subsection A, where it states that after the beneficient receives the final charter and the first regulatory exam has been completed, that's the end of the pilot program. So there's no third requirement there for the OSBC to give an okay for the pilot program to open up. So regardless of whether they received the final charter before December 3rd, upon being able to operate, or later, after the first exam, the pilot program would be over. There's also a suggestion that Beneficient provided its full application in June. I know several members of this committee received carbon copies of letters from the OSBC to beneficent. There were several items that remained outstanding at that time and that have trickled in over time. And that also impacts our ability to the regulations together, to put the proposed legislative changes together, because our primary source of information about TEFIs is the information we requested on the application from beneficent. So as that information has been trickling in, and the financial statements and the background checks are the last two things remaining on that, which leads me to my last point, is that the criteria for granting a final charter under Section 2, and there's a slide that was on the screen earlier that listed off several criteria and said complete, 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 complete. Those were all from subsection C of Section 2. It's also worth pointing out that there are other requirements in Section 2. For example, subsection A says that the application requirements, what information will be required in the application, shall be prescribed by the State Banking Board. That was done here with the application. And again, many of those items remained outstanding and still do. And the criteria in subsection D for the denial of an application, there are two criteria there. There's 5 in the banking code for other institutions. For TEFIs, right now there are 2. And those are, I don't have the statute in front of me, but to summarize them, the first one is financial standing, which directly relates to financial statements, which we have not received. And then the second one is the background of officers, which directly relates to the background check info that we have not received. I think that is, just wanted to address those things that have been brought up. I'll see if the commissioner has more comments to make.
Thank you. Again, please don't interpret that the OSBC is trying to put up roadblocks or create anything adversarial to the creation of a TEFI in Kansas. We just want to do our jobs and follow the law. And the law, as it's written, is what we're trying to do. If the law changes, we will change accordingly. We anticipate the law addressing future TEFIs that we know are going to come. So rather than having to reinvent the wheel for each application and renegotiate each structure like we've done on the initial one, is something that just lacks efficiency. So I appreciate the time for testimony today and would be happy to answer any additional questions.
Any additional questions for the Commissioner's office? Commissioner, on as far as the comment, I mean, I think it was outlined that when the exam happens, the door is open. Any comments on the fact that maybe 12 weeks isn't long enough? I mean, that you might get a number of clients coming in, but would there have been enough transactions to evaluate and enough information to evaluate in that time that says it's time to open it up for everyone else, or you feel comfortable with that?
I think we could get a comfortable flavor of the types of transactions that a FIDFIN transaction actually is, and could see it structured. So again, the 12 weeks is arbitrary based on the speed that beneficent books transactions. So I would hope that we could, by that time, conduct a reasonable exam that is thorough enough for us to provide conclusions.
And your thought is the word conditional necessary in what you're wanting to do rather than a full charter, or is that in your mind the conditional and the 12 weeks or whatever the week is go together, 12, 18 weeks, 6 weeks, whatever, that those conditional and those go together?
we've already issued the conditional charter, so I would hope that upon satisfaction of all of the remaining outstanding issues, that it could immediately become the charter, the full charter.
If it's needed, truly needed by December 31st, uh, could that be done and still in your mind leave the door closed until you get a better feel for what's going on, or it just the conditional puts some more of a line there, I guess, that the full exam lets you cross.
The December 31st date is one of the two, the earlier of us issuing regulations or December 31st for the booking of FID transactions. Presuming that that starts in January 2nd, then the conditional charter remains in effect until we conduct the examination. That's why we want to do the examination as rapidly as we possibly can. And again, arbitrarily, the 12 weeks could turn into 6, but it might turn into 18. But the conditional charter that was granted on July 1 of 2021, the day the law went into effect, and the day that the law said that we would issue, we did. That still remains, and we need to conduct an examination after those transactions are booked, so we have something to look at.
Okay, any questions for the commissioner? Senator Longbine?
Commissioner, if a charter is not issued by December 31st, that would give investors confidence in placing their assets in trust. And then you have no assets to examine. Are we not going to be back here the same time next year with no assets and no charter?
It sounds like it's a risk.
Doesn't make a lot of sense to me.
But if this legislature mandates the bank commissioner's office to issue a charter, it will be the first time, to my knowledge, that it's ever happened for a bank or for a trust company. And I worry about the consequences that to the state banking board of such an action.
So the legislation calls for a charter to be issued either the earliest of December 31st or after rules and regs are made, correct?
It authorizes the commencement of FID-FIN transactions, which builds a book of business for us to examine.
So, Commissioner, is it possible that you could do that? I mean, what Senator Longbine asked, the full charter, but the exam would be the condition for opening the doors?
Well, issuance of the charter is actually a function of the state banking board, not of the office. So I would defer to the state banking board for that decision. But yes, otherwise you are correct.
So I'm not sure what I'm correct on, maybe. Could you, I mean, are you saying that I could be correct that you could do one and delay the other to open the doors until you do the exam?
Again, I can't speak for the state banking board, who is the final authority on the issuance of any sort of charter. But if the banking board so deemed that they could issue their charter at the day following the completion of our examination, then that charter would be a full charter with no conditions attached.
Okay, but it would not be, you're saying it would not, you couldn't do one, issue a full charter, but not open it up until you're satisfied that, satisfied by the exam, that you're saying that likely with the banking board, it would require the conditional to stay in effect until the examination.
It's a really difficult comparison based on the issuance of a charter. For example, if we had a de novo bank, we would test and make certain that the capital was paid in. We would test that the policies and procedures were there, that the board was duly elected. They had completed all of the pre-opening of a startup business. And we would issue the charter. And in the banking environment, within 12 months of issuance, that is when the examination would take place. Again, allowing time to build a book of business, something to go in and take a look at, to examine and draw conclusions. With this, we don't have the same type of pre-opening procedures to go through. We have this act that we will follow and not do those exams, but we have to have something to examine. So that instead of 12 months, we're saying, well, we could do it a lot faster, maybe 12 weeks. But the issuance of the charter is the state banking board's responsibility, and they will ask us, what have you seen? How much capital and how much book, what types of transactions? Are there concentrations? Are there other issues that we brought up? Our answer is simply going to be they have or they have not complied with HB 2074.
Senator Masterson.
Thank you, Mr. Chairman, and I don't have any questions. I think we've probably exhausted that circle. But I do have comments, and I think the committee has the ability to take certain actions, because just giving the comments that we've kind of circulated around, particularly the comments of Chairman Longbine about the sophistication of the investors we're talking about, the time frame that we're talking about, 12/31 in the 2021 tax year. I think the intention of the legislature, I think the intentions of the executive branch, this committee as a joint committee does have the ability to clarify legislative intent, particularly with its makeup. I think we need to give some, if you want it by motion and vote, Mr. Chairman, or otherwise, we have the ability to give the Banking Commissioner's Office clear intention. We are undeniably plowing new ground because the legislature hasn't been done, did mandate a charter be issued on July 1. But we put in these language around conditional, but the full intention of that was to be full, permanent, standard, unrestricted, removal of the word condition, however you want to describe that, no later than 12/31. Because of the sophistication of the investors, because of the sensitive time frame. So I think it would be very important for this committee to actually take an action that clarifies that, because I believe the Commissioner's Office will receive, in the matter of days, very clear instruction from the executive branch as well in this same line. So I would like to, if you want it in the form of a motion, I'd move that this committee give clear instruction, strong recommendation, however you want to phrase it, that a permanent charter be issued no later than 12/31 of 2021 so that practical operation can commence within the pilot program for the examinations to be able to be fully taken place. And I would put that as a motion.
Have a second by Representative Owens. Discussion. Senator Longpine.
Thank you, Mr. Chairman. I agree with President Masterson that was the intent, at least certainly on the Senate side. I can't speak to legislative intent necessarily on the House side. When I spoke earlier about staying in our lane, I think the recommendation is appropriate, but the timing of the examination needs to be determined by the banking commissioner. When it is felt by the office of the OSBC that enough business has been booked, that there are enough things to audit, that we have gone through a pilot program, because the pilot program, according to legislation, will end when that examination occurs. That would be at the discretion of the bank commissioner on, yeah, we're comfortable, we're ready, let's do the examination. If the examination is clean or turns up to meet all guidelines, then there should be enough comfort level to open it up. But I don't want a examination to begin on, or transactions to start on December 31st, examinations start on January 2nd and end on February 1. I don't think that gives us enough time.
So, Mr. Chairman, to respond, that's why I left that so open-ended in my motion, so that the examination could begin or commence. So that timing would be completely up to the office of the banker, when it begins, when it ends. I 100% agree with that sentiment. And so that, I will use those as clarifying remarks in the motion of the commencement of the investigation.
Any other discussion? My thoughts would be, with the motion, we're certainly exiting our lane and going full blast into the bank commissioner's lane on the approval of a charter. And I can certainly understand maybe the concern of a sophisticated investor, but maybe they're sophisticated enough they know that they're in a pilot program. So, and that they have the opportunity to get in on something brand new, and that is fine with them. But anyway, I don't see, no matter what, I'd agree with the senator, at least what I think I understood is that before it's opened up to other TEFIs, that it may be at the discretion of the bank commissioner, and that may be much longer than 12 weeks. It may be 2 months or 3 months or whatever until you get enough information to see. But I hate to be in the position that we are basically stepping into the shoes of the bank board, and we're saying you will issue a charter, because that breaks some tough ground for other banks and other financial things that are going to happen in the state
With all due
in the
respect,
future.
Mr. Chairman, it was a clarification of legislative intent. That's what that motion is, which is 100% in our lane.
Well, and my idea of the legislative intent on the other side was that there would be some guardrails there, and the exam would end, that the conditional was put in so they could have some type of charter. And, in my way of thinking, if the bank commissioner's office says that a conditional charter is a new type of charter that we've issued, and you're allowed to take contributions or to seek business, open it up, that will be a charter. The conditional one may be around forever for other financial ventures in the future. So
Again, Mr. Chairman, with all due respect, that's why a joint committee would take a vote. That's what clarifies, because it's not a single person that makes that. Legislative intent is a broad stroke, and that's why a joint committee would take a vote to clarify legislative intent, no matter what I think as the president of the Senate or you think as a chairman of a committee.
Representative Owen?
Thank you, Mr. Chairman. I second the motion because I agree wholeheartedly. This is clarification of legislative intent, because I believe it was the House's intent as well. That being said, I asked the question earlier, what are we risking? What is truly at risk? We're not talking about people's money. We're not talking about Kansas consumer. We're not talking about taxpayer funding. We're not talking about any of this. What is at risk? in fulfilling legislative intent, and that is simply reputational risk, as shared by Commissioner Herndon. Anybody that has done anything great in the history of this world has taken risk. In most cases, much more risk than just reputational risk in moving first, in being ahead of the competition. They're taking much more enormous risk in the decisions they're making, well above and beyond simply reputational risk. And I am incredibly comfortable staking my reputation and on the line in taking that risk based on the fact that we have fulfilled all of the requirements, and we were very clear in our intent that they get this charter so that they could operate, so that they could be evaluated, and the doors can be flung wide open on what is potentially a $9 trillion industry. The first time in the history of the state of Kansas. This is phenomenal for us not to act, for us not to empower these people to provide this type of economic impact into our state, for us to delay this 1 minute longer than it needs to happen. Is a travesty. And so I fully support this motion and ask everybody else to do the same.
Any
Mr.
other
Chair, if I may.
Yes,
This
go ahead.
Senator Pittman here. Despite Representative Owen's comments there about risk, I might not be as risk-taking as he is, but I still rise in support of the senator's motion. I don't know if we even need to make it legislative. I think it's important, if not critical to the success here, that we make it so that these investors can have confidence and will do the business. And if our trusted partner in this, the pilot program participant, feels as though that's a critical flaw in the way this is proceeding, I think it's well worthy to make the intent that this thing go full charter. So I appreciate the motion. I think that this committee should probably reconvene in the next couple of months and evaluate the length of the pilot and some of those other terms, if not in our committees, if not in some consideration of legislation that could put some clarity on some other things. I think that this committee could add some value there as well. So hopefully we will make this motion, approve it, and then continue on with the pilot program.
Any other comments? So the way that I understand the motion is that the motion is to, on December 31st, the legislative intent is to issue a full charter. However, the legislative intent on opening the program up is under the guidance of the Bank Commissioner's Office and the State Bank Board as to when they are at a point, no hard date, but when they are at a point that they feel safe to open it up to have more come in. That capture.
That is correct, Mr. Chair.
Okay. Okay, we have that down. So we had a motion and a second in our discussion, and all of those in favor of designating and expanding on the legislative intent was to grant the full charter December 31, to close the pilot at the discretion of the Bank Commissioner's Office and the State Bank Board. All those in favor signify by saying aye.
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 Opposed? Aye. So motion passed. Would anyone like their votes recorded?
Mr. Chairman, I would.
Let's see, Senator Fagg, Representative Finney. I would like mine, Representative Owens, Senator Masterson, did you have your hand up? And Representative Hoheisel. Okay.
Can I say something?
You might as well throw me in there too, Chairman.
Okay. Pittman would like his. Representative Finney, did you have a?
No, I just want to say that, we put safeguards in for a reason in Kansas. And I think we have hired our bank commissioner to look out for us. And he's mentioned a couple times that they haven't received the information that they had requested. And with that, I think we need to stay in our own lane, in my opinion. Because if this is, yes, it may be an opportunity, but we don't know for sure how big of an opportunity it is, or it could be a failure. We're taking a chance. And Kansas does have a reputation to uphold. I think we should take our time and give the benefit of the decision of our banking department, the board, and the commissioner. That's what we hired him to do. So that's why I vote no.
Thank you. Any other items to come up? Senator Longbine?
Thank you, Mr. Chairman. It appears like we maybe have gone into our committee discussion with recommendations. And so in looking through the recommended changes in statute from the OSBC, I would make a motion that we have the revisers clean that up into our format and introduce that in each one of the standing committees on both the House and Senate side so that we can take a look at it and evaluate it.
Okay, we have a motion. Senator Masterson seconded the motion to have the reviser take this, put it in our regular bill forms and introduce it, have it ready for introduction into each of our committees when the legislature convenes. Any discussion? No. Okay.
One question, what are we putting into bill form exactly? Are we putting in the motion that we just had, or are we putting in the bill form the OSBC piece?
The
Chairman, for
OSBC's.
clarification, this would be the attachment that was attached to the bank commissioner's testimony.
Yes, and so it would be their recommendation for things that need to be considered in the legislation.
Thank you, Mr. Chair.
Okay. Have the motion and the second. All those in favor of having this put into bill form and ready to be introduced into both the Senate and the House Financial Institutions Committee signify by saying aye.
Aye.
Opposed? Okay. Would you want your vote Okay. Senator, Representative Owens voted no. Okay. Any other items that need to be discussed as far as the direction for the committee report to the 2022 legislature, other than what we've putting in what we discussed today? Okay. Does that give you enough clarification? Do we need to give specific direction?
No, I think we have, we'll have both the comment on the subject of legislative intent, the recommendation for the bill to be introduced in both houses. Does this committee want to either request an update by a date certain, either a joint meeting, or request that the House and Senate committees receive an update on the status, either receiving this report from the joint committee or an update from the conferees you've had today by a date certain?
We could talk about times. I do think that we'd want a report on this committee today, probably right at the beginning of the legislative session into the two committees. That as far as a future report, that was one recommendation that came up from someone, I don't remember, maybe it was Senator Pittman, whether
Mr. Chair.
Whether we have in a period of a month or two have an update as to how it's gone. Senator Longbine?
Thank you, Mr. Chairman. I do think it's important that we stay on top of this, but we will be in session. And as chair people, we can have informational hearings. We can set a day aside to get an update within our committee process. I don't know that I want a full written report until after the examination has been done and the pilot program has maybe been dissolved or is about to be dissolved. That seems like a more appropriate time, but as chair on the Senate side, I'm more than happy to set a day aside somewhere down in the future to get an update from both the company and the OSBC.
Okay, or conceivably, we could set a time where the two committees could get together and get an update on it, whatever would work. Okay.
Mr. Chair, I would prefer we meet as a committee since this is our focus. If we were going to meet with both of those two committees, you get different groups of people together. I don't know. I just would, if we want this thing to proceed in a fashion, I know our committees can get on top of it, but we typically are considering legislation and not really taking action and recommending things as a whole. I'm hoping that we would have enough evidence over the next 3 months that if we haven't had an examination commenced by that point, we would want to initiate some kind of action about why we're not having action at that point, a checkpoint, if you will, to make sure, things are proceeding. And if there are any issues that we're not proceeding, we can take an action, but we can always wait till another date to decide if that's important or not. I think it's important to set the expectation that we want to be on top of this and we have a schedule of examining this and staying on top of it,
Senator Longbine.
Thank you, Mr. Chairman. I do believe that we have a member of LCC here. And so as I understand legislative joint rules, during the session, the chair of that joint committee does have the ability to call a meeting without LCC approval during session. The only time we need session approval is when we are out of session or there would be extra pay involved. So I think the chairman of this will switch January 1. So I would assure the committee that if there is a reason or a need, we will certainly meet during the session to make sure that we stay on top of it.
Okay, any other items?
The only other would be just responding to your review, monitoring, and making recommendations if you wish to provide a comment on the status of the implementation progress. That can certainly be within the body of the report and the information presented, but whether you wanted to make a specific comment to either OSBC or beneficent.
Anyone that wants to make a specific comment in relation to the updates and the progress we've heard today, or is everything covered in what we talked about? I think no specific comment. Any other thing, Melissa, missing? No. Okay. Well, I appreciate everyone being here today. I appreciate Beneficient making the trip from Texas and the commissioner's office, and I know the commissioner's got a plane to catch, so you have to drive pretty fast maybe, but to catch it. And so we will stand adjourned.